May I please, Your Lordship? Lordship, in terms of Lordship's direction, we have filed an additional affidavit. Before reading the same, Lordship, in respect of maintainability ground, Lordship, regarding participation of by the petitioner, already learned senior counsel claims to be realized his judgment.
Yes, tell me.
One Rajkumar, as well as the Nita Sahai, and one judgment passed by this honorable court 2013 5 GLR 750. Apart from that, Lordship, in that similar circumstance, Lordship, one honorable apex court in the 2020 SCC 209 Ramji Singh Kadam. I am relying the paragraph 33 to 40. Paragraph 33, Lordship. From the pleadings on the record and submission made by the learned counsel for the parties, the following points arise for consideration. Whether the respondent petitioner who had participated in the selection were stopped from challenging the selection in the facts of the present case. Now, if Lordship comes to page 38, paragraph 38.
Now, my question is first,
Yes.
what is the leave I granted to you?
Lordship, only because regarding the maintainability already placed 3 judgments. So I, in
No,
addition
not
to
on that. I've granted you the leave to take note, thing on records, a plea pertaining to
Yes,
section
Lord.
73 and 162. That's it.
that's
Did you restrict yourself to that leave?
Lordship, we have already
Did
filed
you
addition.
restrict yourself to that leave? My question is that
Yes, Lord.
you have.
We have-
Obviously, we strike out the paragraphs, paragraph number 5, 6, 7, 8, 9, 10, 11, 12, 13, 14. Why should I allow you to bring on record these aspects?
But regarding the our
Within
one,
wasn't it the submission of the senior counsel that he forgot to bring this particular plea pertaining to 73 and 162? That was the limit.
but regarding the
the
selection board was constituted.
No, Mr. Kolida, is your senior counsel. Where is he?
As Lordship, he is in Manipur. He was supposed to return yesterday, but the matter is again fixed today, Lordship. That's why.
Is your senior counsel trying to act clever with this court?
No, Lordship. Only because
Well, I will do one thing. I will also be applying the same laws to that effect.
Lordship, only
I have
paragraph,
been
paragraph,
lenient. No, Mr. Kulita, first and foremost, you have categorically mentioned earlier
Yes.
that this is the particular admit card of that particular petitioner number 4. Now you are taking a different stand now in this affidavit, isn't it?
Lordship, but ultimately he
The question
appeared.
is, yeah.
Yes, Lordship. Because that was our wrong on our part, Lordship. Because
Therefore, don't you think that
in
this
respect
will
to additional
don't you think that this will require amendment to the petition? Let us be more technical when you want to be trying to play with the court. We do one thing. We'll have it on another day when your senior is present, because he has made that submission before this court, and on the basis of that, I granted him the leave. I would not take it. But the fact that once an advocate tries to act clever with the court, this court also knows how to act clever with them also. You are only supposed to take that plea. You are not supposed to. For that, if you wanted to do it, I would have allowed you. But you should not have acted clever with this court. What do you say, Mr. Advocate General?
I am little bit astonished to see how they have tried to build up a fresh case now,
Absolutely.
which was not, because I have completed my arguments. I have done
Yes.
everything.
No, he only said that he had a submission as pertaining to Section 73, Article 73 and 162, wherein it is stated to the effect that, look here, if there is nothing mentioned out there in the rules,
19
either it has to be mentioned in the rules, or if it is not mentioned in the rules, there has to be a section statutory instructions in terms with executive instruction in terms with Article 73 and 162. I said, okay, if you want to bring, this is a purely a legal submission, you want to plead, he did, I permitted him, so that in the division bench, if he goes out there or anybody goes out there, he can very well take that plea. Though I had rejected on the face of it, on his face, in view of that particular judgment, I said that no, this is the plea does not. However, for the sake that you want to bring the plea, I had. But what he has tried to do, the petitioners, is bring in something more where leave was not sought for. When the leave was not sought for at the stage of reply, I only allowed that. There was nothing more further to hearing to be done. But I only allowed you to put that plea so that they can take a response to that. But you are now bringing an absolutely new case, the Right to Information Act, which you filed on 12/1/2026. Why on earth you did not ask on that date? Did not mention in your writ petition. You are now changing the fact that earlier you applied for 2 jobs. The respondent number 4 or the petitioner number 4. Now you say that in one job you did not get an admit card, in the earlier job you participated.
In additional,
This is a completely change of the scenario which you have brought in. Means again the pleadings has to be done. Now if it is a change, if we apply the judgment of the single bench or coordinate bench of this court in the case of Atinda Adhikari, I think it is authored by Justice Amitav Roy, where he deals with what is the scope of an additional affidavit. The scope of an additional affidavit is to enlarge something which is already there in the pleadings. You can't bring in something new. A plea which is there on the basis of that, I could have allowed you. But otherwise, you have to go for an amendment. Then everybody has a right of filing it. Means you have entirely derailed the entire proceedings, the hearing which was completed. So you did it by yourself, or did you do it on the instructions of your senior?
no, Lordship.
You have done it by yourself, then you take I'll pass the order to that effect. Or you want to do it at the instructions of your senior, obviously, then the thing will be, I'll hear the senior on that.
Or Lordship may fix another date, Lordship.
Now, my question therefore is, did you do it by yourself? Then I can hear you on this. But if you have done on the instructions of your senior, which should have been the other way round, then obviously the senior has to be accountable for making a
Okay.
statement before this court and doing something else.
Lordship, then Lordship
So,
may
Mr.
rely.
Palta, I'm very particular on this. I'm otherwise very lenient on pleadings. I'm not much into this. But if you try to play with the court, obviously, this court will take it up.
See, it's my fault, Lordship.
No.
It's my fault.
Then you need to go for an amendment of the pleadings.
Lordship, only need to
No.
do relevant paragraphs.
No,
Lordship.
this is a fresh plea. It's a new thing which you are bringing in. I can't take into account unless you give up that these paragraphs from paragraph 5 to onwards,
Yes, Lordship.
6 onwards, you don't want to insist.
Yes, Lordship.
File an affidavit to the effect. You don't want to insist, file an affidavit. Because that is beyond the pleadings.
Yes, Lord. I'm saying, say, facing the same problem in another court in the identical way.
Huh?
In identical way, I'm facing the same problem. I finish my arguments, everything is over. In the
No,
second round of
no,
reply,
yeah.
they brought another thing
No,
and the whole
Mr.
case changed.
Advocate General, last time what has happened? They have been all along contesting one thing,
Not
to the effect that, look here, there is no proper instructions to that effect. So they want to develop it by bringing section Article 73 and 162. That is a plea which can be taken or enlarged by way of an additional affidavit. But not in a case where certain new things are being brought in by way of an affidavit, that too at a stage when no leave has been taken, but at the stage when arguments are complete, and on that date he has already completed the arguments. I only gave it that so that others can file their reply and thereupon. But you are bringing a new case. Otherwise, you want to file an affidavit or a amendment to the pleadings, go for it. That is your lookout.
So
We
in
are
this
not
case-
in a hurry now,
So in this case,
as you have
we
taken
are,
so much of time. The matter ought to have been disposed of on 23rd of June. So you have derailed it because on 23rd of June, when I took up the matter, your senior said that look, he has not prepared at that hour. Then again, when the matter came up immediately after the vacation, it has been said that he had two things which he needs to be, which is one is already there, and the other he wants to bring it by way of a short additional affidavit.
so I will file an additional affidavit, Lordship, regarding, I will rely from paragraph 14 onwards. Paragraph 14 onwards.
What paragraph 14?
14,
What is paragraph 14? For 5 to 13, you won't rely upon.
Right.
Paragraph 14 is on the basis of that
yes,
judgment.
yes.
There's no quarrel with that.
15 also, 15, 16 also, 17.
15 is what?
Newton Kumari, Lordship, because they have to notify regarding prescribed criteria. That was our good, Lordship, on that day.
Others are a part of that.
Yes.
File an additional, file an affidavit, not an affidavit, an application for striking off. This is not affidavit. You file an IA for striking off. It will have to be done in terms with order 6, rule 16. This code, by an order dated 14/7/2026, at the request, had given a limited liberty to the petitioners to take the plea that either the statutory rules framed under Article 309 of the Constitution or by way of executive instructions issued under Article 73 or Article 162. The criteria on the basis of which the selection proceedings are to be conducted had to be made by the rulemaking authority or the state. This plea this liberty was granted, taking into account that there are certain factual, on the ground that there are materials in the writ petition by which this plea could be by which the plea, this additional plea could be enlarged by way of an additional affidavit. However, surprisingly, perusal of the affidavit which was filed, at this stage, it is very pertinent to take note of that this court had granted this liberty stage when the petitioner had already completed their arguments. The respondents have also completed the arguments, and the petitioner were required to submit their, were required to reply only on the points of law. However, what is noticed from a perusal of the additional affidavit which was filed on, when did you file it?
20
20
07 2026.
on 27 2026, and more particularly from paragraph number 6 to 13, certain additional factual pleas have been sought to be brought on record. These additional factual pleas runs contrary to the very stand of the petitioners in the writ petition. This court inquired with the learned counsel appearing on behalf of the petitioner as to whether the petitioner would like to seek an amendment to the writ petition to insert these factual pleas which are either contrary or absolutely new the pleadings which were made in the writ petition. Or this court also sought for the learned counsel appearing on behalf of the petitioner submitted. What?
So I am only relying from paragraph 14.
No. So you won't be. Submitted that the petitioners only would rely upon paragraphs numbers 1 to 5.
5 also, Lordship. 5 also in respect of petitioners number 4 I have stated.
1 to 4.
1 to 4.
And 14 to. What is that last paragraph?
14 to 23. 24, Lordship.
Not the paragraph that is
23.
true to my knowledge.
23, Lordship.
Don't bring that.
23, Lordship.
And so. It is the opinion of this court that the said aspect be brought on record by filing an interlocutory application so that these paragraphs can be formally stricken off by passing a separate order. When are you filing it?
Next week, Lordship. Next week by Monday, Lordship.
List this matter upon such application is filed. Let them file. Then we will strike off. Did you file your replies?
We filed a reply, but when I was briefed about the case, I said, I have to argue afresh now. Told my assisting
No,
counsel.
you will be now, therefore, if they strike off these, then you will be only arguing on the question of
Only
60
that point.
62 and
In fact, that was in my
73.
intention also. I will only stick to that only.
Huh?
I was planning to argue only on those points only, not those additional regarding the RTI application, whether he received admit card and all those I would have avoided otherwise also.
No, because that is unnecessary, because he
Yes.
could not have, unless he seeks for an amendment.
Deeply obliged.
You fix a date.
That will be better, Lordship. If
When are you filing it? By Monday.
By Monday.
Mr. K. Kolita, the learned counsel, submits that he would file the application on so and so.
maybe on 12th or 13th. 13th.
You file your application by 3rd of 5th. By 5th, yeah. By 5th of August, comma, list the matter on 13th of August 2020.
Or it can be preponed by 1 week, Lordship. If not inconvenient to the.
Lordship has fixed the matter on.
Then on 6th of August.
6th, the problem is that, anyway, this will be come at the top of the list.
Lordship.
6th.
Lordship has fixed the matter on. Lordship, we have to file it by Monday, Lordship. And
You file by Monday by 3rd. We'll take it up on 6th.
Lordship. Highly honored.
Mr. Advocate General, today I am using paperless courts.
Paper.
Courts. I don't have the file. The file is here. So therefore, for me to get that particular, that is why I was asking paragraph which one is done for. Again, one has to get used. I am only.
It is very convenient, Lordship. I am trying to practice. I've tried it for 1 year. Then again, I gave up. Again, I have restarted it about 2 days ago.
You're using a liquid text.
Liquid text. Very convenient. I forgot all the things. But when in Supreme Court, court number 1, it was mandated that no file is allowed. So during that time, I was regularly appearing.
Okay.
Then I had the practice and use of this. Now, after that, again, I gave up and it is very easy to forget.
I'm the first person to use it. Means I'm on the the guinea pig.
No, not a guinea pig. Our senior additional advocate.
I would be a bit slow today, taking into account. Therefore, they have put also reduced my files today to only 13.
Our senior government advocate Dipankar Nath is very conversant with this. And this morning, while briefing this case, I was taking lesson in liquid text from him. Today, just refreshing my.
In fact,
own
that day I was telling the additional advocate general, taking into account that you have to manage so many files, you need to put those files in a scan and use the liquid text and all. Because others, okay, they may require those files,
Yes.
but because he keeps on moving around, Mr. B. Gogoi, so many
True.
matters out there. So
And for my other work, Lordship.
He said that-
ICC matters.
he said that to put a good word for the iPads to the advocate general.
No, I can give him one present. I have 2 or 3. In fact, to Tauhid Sisti, I have given one
Okay.
as the educational senior counsel.
So that is how I'm putting a good word for the additional advocate.
Now, this is very easy because we have to carry otherwise papers too much
Yes, no, because
while traveling across
he
places.
is appearing in not only the PWD matters, all the other matters, so many matters. So
Oh.
better of having a one file out there, it is better for him. Otherwise, he used to carry a lot of files.
Highly honored.
Matter pertains to promotion to the post of.
In this matter,
UTA.
we have received the instructions yesterday, my lord. I'll pray for 2 weeks' time.
Wait,
I'm
wait,
sorry.
wait,
I'm sorry, my lord.
wait. Oh, I don't know where to. What has happened in the last order?
Lord Chief has granted an interim.
Last order is 22/7, na?
If the appointment order has not been issued, then it shall not be.
8/6. The order. There is only one order.
For the first time it has come, my lord.
Okay. Now you have filed your affidavit.
No, I'll file. I have received the instructions yesterday only, my lord.
The private respondent has also entered appearance.
I passed the limited interim order to the effect.
And he didn't join at that time.
Issued, in the circumstance, respondent number 5 has been issued the appointment letter pursuant to the notification dated so and so, the same shall be subject to outcome. You are joined.
No, Lordship, I'm not joined. I'm not joined.
You will file your affidavit
Lordship, during the course of the day, I'm filing, Lordship.
and you are.
2 weeks time. Because why I'm saying so, one clarification I'll have to ask from them.
Mr. H.K. Das, the learned senior counsel, assisted by so and so, who is also this so and so, submits that the affidavit on behalf of the respondent numbers
3,
3, 4, 6, and
Six.
7, isn't it? No,
Yes.
3, 4, and
3,
6.
7 also.
7 also.
Yes, registered admin below.
Raise 3, 4, 6, and 7 would be filed in 2 weeks' time. Mr. So-and-so, who appears on behalf of respondent number 5, submits that the affidavit would be filed during the course of the day. Considering the above, list this matter on 10th of September 2026. In the meantime, the petitioner is granted the liberty to file the reply to the affidavit filed by respondent number 5. And respondent numbers 3, 4, 6, and 7 shall bring on record its affidavit on or before 27th of August 2026. Petitioner thereupon shall be at liberty to file the reply on or before the next date. The interim order has been given it's made clear, no? That
It's not required to be extended.
No.
It's already there.
okay.
Published.
May it please your lordship. This is regarding a matter where we have challenged an order of the labor code.
Have I passed any order in this matter?
It came up before the
Taking
vacations
into
one.
account that the records are available and there is a stay to the judgment and order passed by the learned labor court. This court finds the decision will be taken up for final disposal accordingly. For final disposal. Okay.
Yes, lordship.
Argue. Who is appearing for the other side? The workman? You are appearing for the respondent means?
The workmen.
Oh, you are the worker?
The basic issue to be dealt with is
Hmm.
whether after an IBC proceeding, the new company can be saddled with a liability that has arisen prior to the IBC proceedings have taken place. Here, Assam Company Limited was saddled with a labor code award regarding appointment of the worker's ward as a bodily worker, and number 2, for payment of an arrear salary. There was a settlement in the labor code vis-a-vis a lok adalat, and that was recorded, and the award was passed. That there is a settlement between the Assam Company, the erstwhile Assam Company Limited, and the worker, that his ward will be appointed as a bodily worker, and also an amount of so and so was to be paid as a arrear salary. Now, Assam Company Limited proceeded with fulfilling one part of that award by appointing the ward as a bodily worker, but the arrear amount was not paid. The amount which has ultimately been conclusively decided as 1,85,000 was not paid. In the meantime, Assam Company Limited entered into an IBC proceeding. Another company filed a Section 7 petition. The matter went into insolvency proceedings. There was a resolution applicant, BRS Ventures Limited. They submitted their resolution plan. It was found to be successful. The COC, the creditors, accepted it. And finally, the NCLT passed an order, thereby allowing the successful resolution applicant to proceed with taking over the company. Accordingly, the company now stands as Assam Company India Limited. This is a new company. Now, everything happened. The award was of 2016. The IBC proceedings culminated into the new company taking over in 2018. In 2021, now the worker files a miscase in the labor code saying that there was an amount that I was supposed to get. It has not been paid. The labor court proceeded with the view that it is a fact that the IBC proceedings comes against him. The labor court accepted everything, but ultimately labor court held that since the worker did not have any knowledge about the proceeding, which in my humble service was not required because there was publications made everywhere. Therefore,
How much is the amount?
1,85,000.
Is the awarded amount?
It is the awarded amount in the miss case. Earlier, it was a settlement. Look at the amount was not quantified. Ultimately, the miscellaneous application that was filed in 2021.
Miscellaneous application was 33C application.
Yes, Lordship.
Anyways, my
Yes.
question is, this is an award which was passed, whereby the worker was entitled to the areas of salary.
It was a amicable settlement which was recorded by the labor
So,
court.
but there was he's entitled to the area of salary. Your basic
Yes.
claim is that in view of the
My claim is that I am a new company.
TRP,
Yes,
in view of the resolution,
resolution.
which was accepted by the NCLT,
Yes.
you cannot be settled with any further debt.
Because I am a new company and I start with a fresh slate. The claim that arose was vis-a-vis the earlier company which went into insolvency. During the resolution application stage, there was a proceeding where any claimant could have filed his claim under Regulation 6 of the IBC. He did not do so. A question may come from this honorable court whether he was intimated or not. There is a order that I have brought in by an additional affidavit, wherein the honorable NCLT has recorded that the resolution applicant has put it notice in the newspapers and everywhere that is required for making a wide publicity of the claims to be. So that was done. So thereafter, it was a prerogative
Now
upon.
tell me, Mr. Sharma,
Yes,
in the IBC, what happens? The new company, there are two forms.
Yes, Lordship.
Either there is a resolution or it is a case of liquidation.
Yes. If
These are the
resolution
two
fails,
forms.
then it proceeds to liquidation.
If there is a resolution, how are the debts looked into?
If it is a resolution, under Regulation 6, the resolution professional who is appointed by the NCLT will give out in newspapers a general publication.
I'm not on that.
Lordship.
My question is, everybody will have debts. There will be a
Everybody
committee
will
of
have
creditors.
debts. They will have to make a claim.
There is a committee of creditors.
There is a committee of creditors appointed. Now, everybody will make their claims.
How will the committee of creditors adjudicate the claims of the various applicants? My question is,
So once the claims comes,
would it be done in terms with section 53?
that I have to check also. Section 53 also was referring to. Distribution of assets 53 loss.
Now, whether an amount which is due to the particular worker or for that account or any amount like pension or anything to that effect would come within the ambit of 53?
There is 53(1)(c) that speaks about wages and any unpaid dues owed to the employees other than workmen.
Have you looked into the judgment of Mozarbeer?
No, not so.
Preparation.
Not that.
Mozarbeer is a judgment wherein the question arose before the Supreme Court after the matter went from NCLT. Is as to whether pension or any dues, which are already quantifiable dues, would be a part of 53 or not. So
Without there being a claim to that effect by the workman.
not required because there is a claim. There is a due. The resolution professional is required to look into that very aspect, that what are the claims. That is why he is being appointed. And thereupon he issues notice to various persons. Now, tomorrow, if the resolution, the IBC makes it very clear, and more particularly thereafter by the Mozarbeer judgment, The claims as regards salaries, which are area salaries, those do not even fall under 53. They are entitled on the basis thereof, because if the earlier company was liable, they have to be liable. This is Mudab.
Even if the claim is not raised by the workman under Regulation 6.
It is, therefore, you are having the resolution professional.
Yes.
He has
Then
to
I
know the
have-
law.
I have to check the resolution plan itself then.
No, he has to know the law. Law is that these aspects are outside. But as regards certain workers' dues, to the effect that this is an amount which is to be payable, so there is a mention 24 months or 12 months. They'll be only getting 12 months. 53, you see? I think 1A or 1B.
B1 24 months.
24 months. Workman's due for a period preceding.
Distribution, insolvency. The following shall rank workman's dues for a period of 24 months preceding the liquidation commencement date.
But this was a case of dismissal. He was dismissed. So he is not a workman at that point of time.
But this is a due which is there. It is a decretal due that as is arrears of salary. Debts owed to the secured creditor. In the event such secured creditor had relinquished security in so and so, wages and any unpaid dues owed to the employees other than the workmen for a period of 12 months preceding
That
the
is-
liquidation. These are the manner in which it is to be looked into. Now,
53(1)(b) subrule 1, workman's due for a period of 24 months preceding the liquidation commencement date.
now kindly come to section 18. Interim resolution professionals shall perform the following duties, namely, collect all information relating to assets, finances, operations of the corporate debtor for determining the financial position of the corporate debtor, including information relating to business so and so, so and so, so and so. Receive, collect, and so and so, so. So these must have been taken into consideration.
Resolution plan is not before me.
No, resolution plan may not include, but whether these were being taken into account. But after all, this is the particular amount. Do you have the Mozambique
So
judgment?
the amount was not quantified in that settlement.
Obviously.
The only language used was.
No, the quantification is done under 33C.
Hmm.
You challenge on the quantification, apart from the other program. Now let's be at the user. Where is the award?
That's it.
Where is the award?
The award is at page 24,
Lecture,
Annexure A.
page 60,
50,
page 67.
24. 24.
What?
Gossip is referring to
Okay.
the initial award. 24 and 25, if Lordship will come.
When the case is by way of an amicable settlement, the admissible dues and salary and other is to be paid within 30 days. Now, this award was passed when?
It was passed in 12/11/2016.
16.
Yes,
And
ma'am.
when did this amount happen? The resolution passed?
The resolution, IBC proceeding started on 26/10/17.
26.
10/17.
And
13/8/2018, the Committee of Creditors accepted the resolution plan. 13/8/18.
POC. And there the amount is not there.
No, and on 20/09/18, the NCLT approved.
20,
20/09/18.
now what happens after the approval of the NCLT?
Then BRS Ventures
It
Limited,
is
which-
binding on all, as per 31.
as per 31(1), it is binding on all.
It is binding on all.
And the new company starts with a fresh slate. Lordship. That is
That's
my
okay.
humble understanding of the matter.
After the order of approval, the moratorium passed, the reasoners shall forward all the records relating to the resolution applicants shall pursuant to the
sorry.
resolution approved and may obtain the necessary approvals provided that where the resolution plan contains a provision for combination.
Claim scheme.
Like Muzabai judgment too.
So I was carrying the judgment of SR Steels of 2020. That
I'll say.
it says about the clean slate, a fresh slate aspect only, that all other claims, whatever is there, if not raised at that point of time, cannot be saddled upon the new company.
No, it is also the responsibility to look into the use also.
By the resolution professional.
2023 9 SSC 499.
Resolution process of corporate persons, regulation. Yeah, regulation 6 to 1.
Here in paragraph number 28, it says,
No, sir.
now so far as section 53 is concerned, it provides for distribution of assets in case of liquidation of a company under IPGs. As per section 53 1B, the workman dues for the period of 24 months preceding the liquidation commencement date shall rank equally between the workman and the secured creditor in the event of such secured creditor has relinquished security in the manner set out in 52. Therefore, workman's dues for the period of 24 months preceding the liquidation commencement date shall have pari passu priority with the dues of the secured creditor. Till there, it's okay.
But I think this is regarding a situation of liquidation. We are at the stage of insolvency.
Wait before that.
Yes, Lordship.
At this stage, it is required to be noted that as per section 36(4) of the IBC, all sums due to any workman or employee from the provident fund, the pension fund, and the gratuity shall not be included in the liquidation estate assets and shall not be used for the recovery in the liquidation. Therefore, a conscious decision has been taken by the Parliament legislature in its wisdom to keep out of all sums due to any workman employed from the provident fund, the pension fund, and the gratuity fund from the liquidation estate assets as per so and so, and the workman dues for the period of so and so commencing dates shall rank equally between the workman dues to that state extent and the dues to the secured creditor. Therefore, the same cannot be said to be arbitrary and so and so. Let's see section 36, how do they do things?
Liquidation estate.
Thirty-six four say assets owned by a third party which are in possession of the corporate debtor, including assets held in trust for any third party. Bailment contracts, all sums due to an workman or employee from the provident fund, the pension fund, and the gratuity fund. Other contractual arrangements which do not stipulate transfer of title but only use of assets. Such other assets as we notify, assets so and so. This is for liquidation.
Liquidation also. If your lordship will see the regulations 2016, which speaks about the regulation 6, therein in an insolvency proceeding,
Where?
the Insolvency Bankruptcy Board of India Insolvency Resolution Process for Corporate Persons Regulation 2016.
What did you say?
The lordship is same 2024.
Public announcement.
Is your lordship holding the Bear Act of 2024? Then it is page 181. I'm referring to the Regulation 2016 Corporate Person. This is the requirement under an insolvency proceeding. Regulation 6. I'm building up my case on Regulation 6, lordship. That this is what is required. The resolution professional had done it, but the workman did not apply under this. Or the ex-workman.
Oh.
36A.
To 9.
Lordship, 9. Claims by workmen and employees.
Intend professional or the so and so as the case may be shall verify every
Shall
claim as
submit.
the insolvency within the 7 days
Yes.
from the last date of
Shall submit, lordship.
in a list of which does not collate the claim of the verification shall provide details. In the event that claims are received after specified under so and so. So these proceedings, when was the award passed?
The award, the Labor Court Award, on 12/11/2016.
No, not the other one.
Lordship. The second one.
11/2016. What was
And-
the other one?
The other one was passed on 19/4/2021 when the miscellaneous application was filed. However, not under 33C.
Huh?
The miscellaneous application was filed by the workman was not filed under 33C. He simply filed an application saying, yes, I understand.
is
I
their
understand. It
name?
has to be treated as a 33C application.
And that is for quantify.
I understand. And the prayer was to pay the admissible dues. But that was filed in 2021, much after everything had happened, and against the new company law. So Regulation 9 also requires that the workman has to make the submission of his claims. Yes. 36. What is A है पशुमा? 36 A আছে. This is 2. তাতে workman কথা আছে নেকি? Our case is
Where is the resolution plan?
resolution plan is not with us, Your Honor.
You have not placed it before the court.
Before the labor court, I do not think so, Lord, sir.
Then how are you saying that there has been an insolvency carried out without the resolution plan?
Just a minute, sir. The written objection was there. Written objection we have taken.
Written objection is not a document, it is not a evidence. We also, as of now, also we don't know that there exists a resolution plan.
Court, the NCLT orders I have annexed, Lord, sir.
I'm not concerned to that. What is the resolution plan?
Resolution plan.
Whether it is there or not, whether it is inside the resolution plan or not.
The labor court gave a finding that the workman did not apply for the claims.
Maybe.
But though he did not apply, the labor court took a different view, saying he was ignorant. That was the line.
Okay.
So therefore,
I am not here. I am not going to touch on that amount, what is fixed, unless you say something. My only question is, should this court pass an order or should I ask the the workman to approach the NCLT? It is the only question I'm on. I'm not going to touch the award. The award remains as it is.
we
My
also
only
do not
question
know.
is to help out the workman how he gets the money.
My concern, so to be very honest, my concern is not this 1,85,000. My concern is if the doors are open, there may be hundreds of applications from earlier workmen who may say, we were working under this company.
No, not that. These are not the question out here. Here
Because-
I am not, that is not the question.
Because it will
Here
change
is the
the,
question that I'm not on that. We are specific to a case. There is already an award passed on 12/11/2016,
16.
much prior to the Section 7 proceedings.
correct,
Okay.
correct.
So at that point of time, the amount was to be paid.
Though not quantified in the
Within-
labor
no,
court order,
within
but
30 days.
30 days.
You
It was
did
not paid.
You did not make the payment within 30 days, which led to a
Not-
proceedings under 33C.
Not me, the earlier company loss. I'm a new company with your losses.
Maybe you are.
I
you
was
are
not
the
a party. I was
you
not
are
a party to that labor court
successor in
proceeding.
interest. There's nothing to the.
No, the legal
That
proposition I'm
amount has
saying.
not been paid, so therefore the question arose out here.
So it will remain.
Now, whether the question is, this court is not going to touch that. Only the question is this amount, whether the petitioner should approach this court or the petitioner has not approached here. The petitioner now having made that, as there is already a resolution plan, should he approach the NCLT?
He approached the labor court. And labor court passed this order against which this new companies issued lawsuits under.
No, the only
rural
thing is can the labor court, now what is the labor court doing? The labor court is trying to enforce the award dated 12/11.
Yes.
That is the
Yes.
12/11/2016.
Yes.
That order is sought to be enforced.
Yes, lordship. So therein I am
So
saying
the
that the labor court.
enforcement, it be done by the labor court or can it be done by the NCLT is the question. The award remains as it is. Award of 12/11/2016 is not to be touched. Neither the quantification.
16 we are also not touching.
Neither the quantification, unless you say the quantification is wrong. No, there's nothing to the effect.
I cannot say wrong or right because I don't know.
No. So unless, because you had appeared. You had appeared out there and submitted your written submission, objection.
On the ground saying that legal propositions are against the workmen.
You are only on the legal proposition.
IBC
Only
provisions.
legal proposition is whether they have filed an application before the authority concerned, before the labor court, for the purpose of taking action, because obviously no action can be taken against the corporate debtor, neither against them for not in view of section 32.
32.
No action can be taken against them or them in view of any violation to that or award. But what can be done is how do you enforce it? You have not filed that application, I suppose.
No.
Not also industrial dispute sector. But what is wrong, Mr. Sharma, in quantification?
In quantification.
This is a quantification. The award is, this is not this order is a quantification. They
Along
have
with
put
the
it as an award and be an award. It is a quantification. The award
have
has already
quantified
been
it.
passed on 12/11.
Yes, but the direction is for us to pay.
It
That is where the grievance lies, lordship, because I had started with a fresh slate, as the word been coined by the Supreme Court in SRCs also, and as per 31(1). I cannot be saddled with a liability that arose prior to me coming into the picture, because my resolution plan, which was approved, had considered all the debts and the liabilities, and I have paid that, and that is why the company is given to me on a fresh slate or on a clean slate now. Today, therefore, I have been saddled with a claim arising prior to that, is what, in my humble submission, the Act as well as the Supreme Court judgments would say that it is not applicable in so far as a new
Does the
applicant.
Supreme Court refer
And
relates to workmen?
lordship. Therefore,
Is the Supreme Court judgment saying anything as regards the claims of the workmen?
it says whatever claims have to be raised as per the regulations. And I have, so if lordship have already seen Regulation 6 and Regulation 9. Regulation 9 deals particularly with workmen. Therein, it is the duty of the workman to raise the claim before the resolution professional. Section Rule Regulation 9. That has not been done. That is my case.
How do you know?
Having it not been done, therefore the resolution plan did not incorporate that claim of the workman. So what was given to me means the new company, I have paid that amount, that this is the liability, will you pay? I said, yes, I will pay. I paid, and then the company was given to me to run it afresh or in a new manner. Now I am been saddled with an earlier debt, which could not have been saddled upon me. That is the case. And if the workman had a case, under Regulation 9, he should have applied. And it's an admitted case in the labor court also that he did not apply. But labor court took a view that he was ignorant. That ignorance cannot be an excuse because it was publicly announced.
Now, has the labor court then forwarded the amount to the appropriate government? When you file the application and the application, and an order was passed on 19/4, saying that they have to pay. Has it been forwarded to the appropriate government?
I think it will be published in the official gazette, every award. One second, madam.
Has to be done in terms of- It's not an award. Award is the 12/11/2006.
Yes,
If there is a violation to the award, 29 comes into picture.
29 comes in.
29 amounts to punishment and all this. The punishment cannot happen in view of 30.
Hmm.
Now the amount which is due, payable by the labor court after being adjudicated upon, that appears to be requirement of an application to be filed by them before the NCL. Let the NCLT take into call whether the service was there or not. How can I look into it? Whether regulation 6 was at all adhered to or not? How do I know?
No, that is the finding, it is not.
Who says?
The labor court.
That what? How can the labor court decide that? Labor court was only to quantify as per 33C. There's nothing more than that.
Because the discussions of the labor court would indicate,
Where were the discussions? My question is, the labor court's only duty was to quantify under 33C.
that also he has done on verbal submission only, because there has been no evidence led for that amount.
No, whatever may be,
Yes.
the amount you had the opportunity of objecting.
We
You
objected on the legal aspect
question of
only.
jurisdiction.
Yes.
Now the question is, the labor court have quantified it. Only purpose it has done is quantified.
But can it be
No,
applicable
it is a
upon?
quantification.
Yes.
Now, how does does it normally work? The labor court then places it before the appropriate government. Appropriate government then will send it to the collector. The collector will recover it as a payment of, recover it as as the Baki proceed.
Baki Jai proceed.
So this is the manner in which the collection is to be carried. Now here the award was passed prior to the Section 7 application. So therefore, as on that date, the award was there.
Yes.
So thereupon, what the labor court did out here, which is the subject matter of challenge, is only the quantification. Now, once
Directing us to pay
understood,
along with that.
understood. But for the purpose of giving effect to that direction, the petitioner would be required to move the NCLT.
Till quantification,
Not you.
then I cannot have any objection.
Not you, they.
I understand
The
what I'm saying.
government has to move the NCLT. NCLT will look into it as to whether it has been done as per so and so.
Then lordship, the direction by the labor court upon us to pay, that has to be interfered with by your lordship.
Only to that extent,
Yes.
thereby giving them the opportunity to move the NCLT.
And then my defense under the law remains, because I can raise it before the NCLT then, that it is not here and not entitled. Against me, the claim cannot be exercised against me.
No, whether these dues, which is payable to the workman on the basis of an award, NCLT will decide.
After hearing us, so therefore my defense remains. That's what I'm trying to say.
How do I know whether the
No.
NCLT judge is good enough to give you a notice or not? Don't bring that in there. These NCLT. No,
Because we did not argue on the quantum, because we did not know on the quantum. Our entire case was after 31-1, I am not supposed to make this payment. Whatever amount you have held, it may be against the erstwhile company, who ultimately it has now become insolvent. But it cannot be applicable upon me.
No, if there was a mistake committed by them, by not properly issuing notice, because there is a requirement As per six.
Regulation 6
no,
was
a public
complied.
notification has to be given.
It was done. It was
Now,
done.
whether this public notification was given in a proper newspaper or not, how many newspapers it was given, whether it
NC
was in the newspaper within which jurisdiction the petitioner was residing, where the publication was carried out.
NCLT's order, page 103, refers to our announcements. It refers to that. Yes, I'm just reading the small
Not
paragraph.
your announcement. You did not come into the picture at the stage of
No, no,
section six.
no, no, not me.
Rule 6.
Not me. The resolution professionals.
So whether it is
Compliance
done
of
properly
Regulation
or not,
6.
let the NCLT look into it. That is their lookout. Should we look into it? Madam, I think that is a fair order. There's no other way out. We have a difficult, but I think
One
you
thing
to
I'd like to
NCLT
point
would be
out
the
here.
only way.
So far as this claim of, under section 9, claim of workmen and employees is concerned, my lord. Here that
Under?
proviso,
Regulation 9.
regulation 9, my lord.
Ah.
Here I found one proviso also. That a person claiming to be a workman or an employee of the corporator shall submit claim with so and so to the interim resolution professional in person by post or by electronic means informally of the schedule 1, provided that such person may submit supplementary documents or clarification in support of the claims on his own or
Madam, that would not apply. I have looked into it. This
One
is
thing
before
I
the
did find-
COC is formed. Now
COC.
COC has been formed. COC has decided
clear.
that. And on the basis of that, the resolution profession AI had come in, the
Right.
resolution
Preliminary
plan had come in.
come.
So that would not apply. But you need to hit it on regulation 6.
So that one.
I think this is the case which NCLT and if necessary, the Supreme Court may also like to ponder upon, because otherwise, this, you see, just for example, a small workman, this particular workman concerned, there is an award being passed.
Right.
And
Yeah,
or
this is
here
the
only
fact
one,
really
there are
one.
many other people who were working with me. And then tomorrow, the COC is not involved with those workmen out there. Everybody
be
knows
possible.
out there how the resolution professionals work out there. And after that, they give a report to that effect. Once they give that report to that effect, it is being accepted.
Right.
Once it is accepted, then what will happen to those workers who could not approach?
Lodge. That is
We
the
are in a tea
difficulty.
garden. In a tea garden, there are so many workers who may not know how to read.
Lordship,
To consider that.
practical
There
situation.
are many workmen who may not read. They are daily wagers. How I don't think that the insolvency bankruptcy this act is such that all the rights of the workmen, because
be
if you
taken
see
away.
section 53, section 36, it gives a flavor that to that effect, and more particularly the Mozartware judgment, it categorically says that they have the highest priority in as regards the dues.
Lodge.
So these are things which I think to here, I think
Lots
this
of,
is a matter which needs
I think that is more particularly true insofar as liquidation is concerned.
same
Mozartware as well
Mr.
as-
Sharma, the same
Some
principles duly apply in all cases. After all, the workers are always protected.
So
The dues of the workers, it has been always being, you see, the moment the workers come in, the manner in which the court has to look into the legislation is different from what happens to a normal creditor. A bank or anybody
I
else, it's a
understand,
different
I
aspect of the matter. But workers are different. They are only getting some, this is how many areas of how many years?
I do not know. I have no knowledge.
Areas of how many years these areas is being paid?
I do not.
To be paid within 30 days. And these 30 days have gone. No.
Much better.
So page 78 is the direction against the company. If your lordship may just look at that direction. Quantification, yes, I'm with your lordship regarding that. Just the last part, page 78, the last part. It starts with two
Heard
with
Mr. A. Sharma, the learned counsel, appearing on behalf of the petitioner. So and so appears on behalf of the respondent.
Legal aid counsel.
So and so appears as the legal aid counsel for the respondent. Presently, petition has been filed, assailing The order dated 19/4/2021 passed by the learned Labour Court Dibrugarh in Miss Case number 1/2018 arising out of reference case number 4/2016. The brief facts of the instant case as it appears from the materials on record is that the petitioner herein is a company registered under the provisions of the Companies Act 1956. A company, namely Assam Tea Company, owned various tea states, including a tea state in the name and style of Maijan Tea State.
Yes.
Disputes arose, and industrial disputes arose. When the management of the Maijan Tea State dismissed the respondent with effect from 15/12/2014. Under such circumstances, the appropriate government, by the notification number GLR dot 135/2015/30 dated 6/2/2016, issued a notification under section 10 referring the dispute to the learned Labour Court of Assam at Dibrugarh. The said reference so made was registered and numbered as reference case number 4/2016. While the said reference proceedings were taken up for hearing in the National Lok Adalat on 12/11/2016, the management of the Maijan Tea State, as well as the respondent herein, agreed to an amicable settlement whereby the management of Maijan Tea State whereby and have entered into an amicable settlement. In terms with the amicable settlement, though the respondent would not be reinstated in service, the management had agreed to pay full back wages with effect from the date of his dismissal of his service till 12/11/2016. The management also agreed to provide the workmen full service benefits, including retirement benefits, etc. And additionally, an amount of rupees 5,000 would be paid as compensation to the respondent. In addition to that, the management also agreed to appoint a bodily worker, BOD
LI.
LI worker. After assessing the suitability and fitness of the bodily worker, which is going to be appointed.
It was done.
Basis of this amicable settlement, an award was passed on 12/11/2016 itself. It has been brought to the notice of this court that in the meantime, the respondent have been appointed as the bodily worker.
Respondent's son, the
Respondent's son
workman's son, has been appointed as the bodily worker.
has been,
Huh?
Son-in-law.
Son-in-law, son-in-law,
Mentioned in page 73.
son-in-law.
son-in-law has been appointed as a, what happened to the respondent?
He was
Nothing.
dismissed.
He was
That's okay.
dismissed.
So that has no relevance.
No, that is not relevant.
Pusto. It is an admitted fact that in terms with the award dated 12/11/2016, the respondent herein neither was paid the full back wages with effect from the date of the dismissal of his service till 12/11/2016, nor provided the workman, the respondent, full service benefits, including retirement benefits.
Yes.
The respondent was also not paid the compensation which was duly agreed. By the management of the Maijanti state. Next. As stated above, the company, namely Assam Company Limited, was the owner of various tea states, including Maijanti state. Here the name is also Assam Company India Limited. Page 26.
The name remained the same. It is ultimately BRS Ventures. Philosophy will see the final order of the NCLT.
How can you file? You are not in existence.
The board resolution is also Assam Company India Limited. That I have
Maybe,
received.
but you say that the earlier company was also Assam
I think
Company
the
India
name has
Limited.
remained the same. The name has remained the same, Lordship.
Then
If Lordship will just see the last order of the NCLT, page 64.
Yeah.
64.
what is this?
This is the final order of the NCLT, paragraph 13. Page 64, the last paragraph, paragraph 13. The final order.
So the company remains as it is.
Yes, by VRS, no, ultimately the owners have changed. VRS Ventures Investment Limited. They are the resolution applicant, successful resolution applicant. Company name has remained the same. Resolution applicant is this.
So the company is the same. Ownership has changed.
Company name remains the same.
Company is the same. Ownership has changed. That is what you say.
Yes.
The Assam Company India Limited. Petitioner is the company.
Name remained the same, but owners have changed. Yes. So we are new owners. Correct.
Petitioner. It is MS Assam Company India Limited is the company registered under it. Huh? Petitioner company owned various tea states, including a tea state in the name and style of Maizan. Next. Well, the petitioner company did not comply with the amicable settlement, while the management of the petitioner, management of Maizan tea state did not comply with the amicable settlement, which was reduced in the form of an award dated 12/11/2016. The company which owned, the petitioner company who owned the Maizan tea state was involved in the proceedings of insolvency before the National Company Law Tribunal Gauhati bench. On the basis of an application filed by a company, namely Seri Infrastructure B (P) Limited,
It was finally registered as case number 20.
it is further seen that a company in the name and style of PRS Ventures Investment Limited submitted a resolution plan to the committee of creditors who were formed, the committee of creditors. And this resolution plans was submitted by by BRS Ventures Investment Limited was accepted. By the committee of creditors. The final resolution plan thereupon was placed before the National Company Law Board Tribunal. National Company Law Tribunal.
Right.
And by an order dated
29/2018.
9
2018.
2018,
Starts at page 58.
the learned National Company Law Tribunal granted the approval holding inter alia that the final resolution plan was in conformity with section 30(2) of the Insolvency Bankruptcy Code 2016. the meantime, petitioner having not been made payment of the respondent having not been made the payment, the dues in terms with the award dated 12/11/2016, filed an application before the learned labor court.
Page 47.
For quantifying the dues payable to the petitioner, to the respondent. And other ancillary dues. This application was registered and numbered as Miss Case number 1/2018. In a company, who's in the meantime your shareholding only changed. Shareholder changed.
Shareholders,
Company remained as it is.
the company was
You
taken
change
over.
your registration.
These informations,
No, these are things which needs to be placed.
this information I do not have. I apologize.
The petitioner company, in the meantime, whose board of director changed in view of the corporate resolution, in view of the resolution plan, having been approved by the NCLT in the order dated 29/2018, filed written objection raising the plea that in view of the acceptance of the resolution plan by the learned NCLT, no liability can be settled upon the petitioner company pursuant to on the basis of the award dated 12/11/2016.
WS was filed on 18/2/21. Much after the resolution had happened.
The London Labour Court by the impugned order dated
19/4/21.
19/4/2021
Page 75 is a discussion also. Page 75, last.
quantified the dues payable to the petitioner to the tune of rupees 1,85,175. along with other fringe benefits, if any. Within 2 months from the date of passing of the said order. It was further observed that failure to do so would result in invoking proceedings under Section 29 of the Industrial Disputes Act 1947. It is under such circumstances the petitioner has approached this court by filing the present writ petition. We come back.
Yes, sir.
These are the judgments you are referring to, Electro Steel.
SR Steel, if I may just place this.
SR.
On the aspect of that fresh slate concept. Paragraph 105 and 107. One zero five and more particularly also 107.
And
Only this logic. On the concept that he starts with a fresh slate. So any earlier undecided claims, if not raised as per the regulations 6 and 9, cannot be saddled upon the press company, the successful resolution applicant. And that was the ground also taken by us in the WS only. Nothing on merits, but on that aspect only. Because merits, otherwise we do not have the information.
SR is 2019.
2028 SCC. It was decided on 15th of November 2019. $531 is.
Internet battery.
This was also referred in a subsequent judgment of 2021 also. Arun Kumar Jagat Ramka versus Jindal Steel.
No, the issue was taken up in I think Bhushan Steel also this issue was. Judgment to an option. 2021, 9 SCC 657. So only on the question pertaining to whether there was proper publication or not, that can be looked into by NCLT. Otherwise, you have a difficulty, Mel.
NCLT in one of its orders, interlocutory orders, have stated that it has been duly complied with.
Not
I have
gonna-
annexed it in additional affidavit.
It has been complied with, whether it has been complied to that effect or not, these are aspects which the NCLT looked into. Why should I? I have 102 stocks. No? And this is 657.
In fact, under Regulation 6, the requirement is one English newspaper and one regional newspaper. And now the findings of the NCLT in one of the interlocutory orders is that it was made in 4 newspapers. The IRP made paper publication and public announcement.
102.
The IRP made paper publication and public announcement in Business Standard, Ek Din, Amar Ahom, and BS India, dated so and so.
And?
Right? And Amar Ahom and BS India.
Yes,
Dated-
India, have you heard of Assam? Business standard. And then,
Business Standard, Ek Din, Amar Ahom is popular.
and what else? BSc?
Business Standard,
Not there.
Ek Din,
Egg?
that is Ek Din, one day, Ek Din.
Egg din.
I
Hindi.
think Hindi, because a lot of workers read Hindi newspapers also.
Where is it published in Assam? In
Maybe those areas, Lordship. Maizan Tea State areas, maybe.
absolutely no, I've never heard of that. And
Amar, Lordship will know better. Amar Ahom and BS India. But satisfaction was recorded.
62B is also there, where that operation is being taken up for the company, my lord. In that place, notice has to also be issued, my lord. I have taken a plea in my reply also, my lord. For that part, only newspaper publication has been announced.
be published in one English or one regional
Newspaper.
with wide circulation at the and the principal office, if any of the corporate debtor, and in the opinion of the interim resolution professional, the corporate debtor conducts material business on the website, if any, of the corporate debtor, on the site, if any.
My guess is that
Right, let's look. This aspect, let the NCLT look
Lodge.
into it.
That
Why should we
provision is
look
there,
into
my
it?
lord. I
You
will
see, they
continue.
get a clean slate
Lodge.
in view of these judgments subject to the publication made under Regulation 6. Now, whether in the area of Maizan, these are the newspapers which are there, let the NCLT look into it. Again to the liberty.
That is
Just,
specifically I have
one,
taken in
just
my
one,
application.
one aspect is troubling me. Will it be open for adjudication because it has ultimately culminated into a final?
If it has not been done in that manner,
Means if it is
then
not
this court will look into it as to whether these newspapers are mainly because
Because the
NCLT says that
NCLT order is not under
right
challenge
now.
before this honorable court. That order is not.
So therefore, we may very well, if you want, this court can look into and say that these are not newspapers which are there. And thereby it will totally take note of your entire resolution plan will.
That is not under challenge before this honorable court. That is
Not
what.
necessary. But the fact that whether you can just take away the petitioner's rights on that, yes, you get a clean slate. Clean slate is subject to regulation 6.
Regulation 6 and regulation 9 compliance by the workman, where he has to apply.
Regulation 9 will only come if 6 is done.
My case is 6 is done.
After 6.
It is yours. So let the NCLT look into it, that aspect. Because if it is not done, you put yourself at harm's way as regards your resolution. And then once the dent is being put out there, it will affect the entire resolution. It will reopen everything.
That is my concern, whether it is
So better
open,
pay that
open for an
1,85,000
adjudication.
and finish it off outside the court, mediation, not here.
I leave it to your lordships on that
Oh,
aspect, but
so
I'm
therefore-
just expressing my concern whether it's open for,
If
It
lordship,
will be open for everybody.
that
The
ultimately
the
culminated into
moment,
final law.
no, I'm saying the moment it is found out that in the area, where is Maijan?
Dibrugarh side, Upper Assam,
You
Dibrugarh.
don't have the business standards being read by tea workers. You don't have business, they're Egdin read by these tea workers. Egdin I have never heard
Regulation
of.
6 is not only for workers, it is for all
No,
creditors.
I'm
So
not
they-
concerned. We are concerned with the
not
worker.
excluding
Yeah.
him, my lord.
But
And
Yeah,
it will not-
you see, they conduct their business. Assam company has their business in Dibrugarh.
Dibrugarh.
So this is the Assam company's thing. Number 3 is, you say about what newspaper? Amar Home.
Amar Home.
We also know what is the circulation of Amar Home compared to Proceeding and all. And the third is as regards this.
PS India.
Huh?
PS India.
BS India. My goodness.
But the
Tea
court has
workers
recorded
do
its satisfaction on that aspect, lordship. The NCLT
Anyways,
court,
I'll put that note so that it will help you out there in the NCLT.
If lordship gave some indication regarding mediation also, my lord.
No, non-mediation. Mediation not
Or some
necessary.
amicable settlement. my lord,
Mediation,
that will be
mediation,
acceptable.
no. They say that they pay that 185, then it is okay. Otherwise, no mediation. They pay as a solitary case. They are going to give it, taking into account something to that effect. It is a different thing. Otherwise, no.
I can take instructions on that. My instruction basically is tomorrow it should not open a floodgate because
No,
we
no,
will,
it
then
won't
it
be.
will have
This
an effect of changing the
This-
law.
Because everybody does not have an award.
We
Actually,
do not
yeah.
know.
No, no.
No, no.
If
Mr.
The one thing
Sharma,
is-
Mr. Sharma,
Because hesitation-
the first and foremost is, if you see, it is also amended, once there is an award prior to that,
Yes. Yes, dear.
it will be recorded in its books. Whether that was a part taken, whether claim is filed or not is another thing. It is also the duty of the interim resolution professional to
the-
look into that aspect.
Dates also.
Whether claim is made or not, that is another thing. But there was a claim to be paid in the year 2016 itself, much prior to the initiation of a proceedings under 2017.
accepted.
See, if it was any other entity, I would have obviously applied the clean slate doctrine out there and finished it off.
I understand. I
But
understand.
here is the case that a person have got, and this particular person did not get a single penny. So therefore, merely I would have understood that he was given the job. No,
His son-in-law was given the job.
hardly matters. When I read the award only, I came to know, no, he's not even been reinstated, but you are supposed to give the retirement benefits. That is also not being given. So obviously, you need to, whatever may be, as of now, the company has changed. Company remains the same. The directors have changed.
Shareholders have changed. That's
The
what.
shareholders or the directors have changed. So therefore, now they having only changed. Obviously, you have the support of SR, Electro-Steel, then Gyansham Mishra,
That's-
then you have Bhushan Power. All these things are there, which gives
I
you
just
a.
know, I just
which
know
gives
one
you a
only, not
clean
the
sheet.
others.
But this clean sheet is dependent on
Crores of
Six.
claims are in the air, my lord. endorsement. In those cases, that liquidation purpose was matlab for crores of rupees, not for lakh or 2 lakhs.
It's not the
rupees.
quantum, actually. It's not about the quantum per se that the company is fighting.
The
Is that
secretary- that is
if a law is said that even after a company comes into picture, after a resolution plan is successful, and he's saddled with previous liabilities, which are
No,
not
no,
being paid,
obviously it won't.
it may have
It
far-reaching
won't,
effects
it
thereafter.
won't,
That
it
is
won't. But
that
the
is the
fact
concern.
remains that if the person had no knowledge,
Knowledge is dependent upon regulation 6.
so therefore as to whether the publication was in accordance with that.
And my submission is the court has found satisfaction in the publication that was done pursuant to
But it
regulation
was
6.
not brought to the notice by anybody about Rule 6.
He, the workman.
The workman never brought it. The workman never participated in the said proceeding.
That is not the requirement under regulation 6.
So therefore, the workman never participated.
I didn't participate. That is our case.
Therefore, the question here is as to whether workman had the opportunity also. So let the NCLT look into that.
Only on that aspect, also. Only regard vis-a-vis the workman only. Vis-a-vis the workman, whether the workman had the knowledge, whether regulation 6 compliance by the resolution professional would
Whether
have
it
amounted
whether
amounted
it
to
was
bringing
in
it.
terms with section 6, rule 6(2)(b).
That is why I'm saying
The publication has to be done in that manner, 6(2)(b).
that manner is-
So whether it was done in that manner, and if it was done, very good, you be happy. And if it was not done, you know the consequences. And
Again,
Mr. Sharma, I had also had the experience of practicing out there in the NCLT. And I know what it takes to become the final acceptance of the resolution professional. The resolution plan acceptance is also a big,
Okay. I have not read.
oh, it is a very big thing. The COC, how they act. Is not a very small thing. How much of what goes on behind all this, the doors
have
out
heard
there for
rumors.
COC,
I have heard
yeah,
rumors.
it's a very difficult thing. Would your clients like the tinkering with these things after having spent such a huge amount?
the bad.
And that is my concern, whether the final judgment can be reopened now. Because if Lordship is looking
It's
into
not the
regulation
reopening.
6,
You see, the fact that it is not on the, I'm not saying about a new case. This happened, there's no quarrel that there was an award.
yes, we are also accepting to that.
He had a claim. There's no quarrel with that. He had a claim. Did he have the opportunity of filing an application before or submitting his claim? This is a question, let them look into it.
Yes, Lordship. Whether regulation 6 was complied in its proper nature as required under the.
Mr. A. Sharma, the learned counsel. Mr. A. Sharma, the learned counsel appearing on behalf of the petitioner submits. That when a resolution plan has been approved by the NCLT under section 31 of the Insolvency and Bankruptcy Code 2016, for short, the code, all the existing claims or debts all the claims as provided in the resolution plan shall stand frozen and would be binding on the corporate debtor and its employees, members, creditors, including the central government or the state government or any local authority, guarantors and other stakeholders. The learned counsel submitted that upon the approval of the resolution plan on 29/2018 by the learned NCLT, all such claims which were not part of the resolution plan shall stand extinguished, and no person will be entitled to initiate or continue any proceedings in respect to the claim which is not a part of the resolution plan. And therefore, so in that, the learned counsel therefore submitted that in the instant case, the petition, the respondent herein neither did submit his claims in terms with
Regulation 9.
Regulation 9 of the Insolvency and Bankruptcy Board of India, bracket Insolvency Resolution Process for Corporate Persons, bracket close, Regulation 2016, for short, the Regulations of 2016. And therefore, now cannot claim any amount on the basis of the award dated 12/11/2016. The learned counsel therefore submitted that the impugned order dated 19/4/2021 was passed completely disregarding the settled principles of law as held by the Supreme Court in the case of the Committee of Creditors of SR Steel versus Satish Kumar Gupta and others, reported in 2020 8 SEC 531. Yansham Mishra and Sons Private Limited versus Edelweiss Asset Reconstruction Co. Limited, reported in 2021 9 SEC 57. Per contra, Ms. M. Borman, the learned counsel, the learned legal aid counsel submitted that it is only that section 31 only refers to the extinguishment of such claims which are a part of the resolution plan. And not in respect to those claims which were never taken into consideration by the resolution professional when the corporate debtor was not granted an adequate opportunity to submit the claims in terms with Regulation 9 of the Regulations of 2016. The learned legal aid counsel further submitted that the perusal of Rule 6, Regulation 6 of the Regulation of 2016 refers to public announcement and in the manner in which the public announcement is to be carried out. The Learned Legal Aid Council, referring to clause regulation 6(2)(b), submitted that the publications was required to be carried out in one English and one regional language newspaper with wide circulation at the location of the registered office and the principal office, if any, of the corporate debtor, and any other location where, in the opinion of the interim resolution professional, the corporate debtor does not conducts material business operations. The Learned Legal Aid Council submitted that the Assam Company India Limited conducted its business of tea plantation in various localities, including where is Maijanti state? Including in the district of Dibrugarh. The publications which have been made as submitted by the Learned Council appearing on behalf of the petitioner in respect to two English dailies and one regional language and one Hindi newspaper are newspapers which are not widely circulated in the district of Dibrugarh. The Learned Legal Aid Council also submitted that the award was passed on 12/11/2016. And it was the duty of the resolution professional in terms with section 18 to collect all informations relating to the assets, finances, operations of corporate debtor for determining the financial position of the corporate debtor, which also included the dues to the workmen. The Learned Council therefore submitted that merely because of the settled principles of law which gives a clean slate to the you are the resolution applicant, na?
Resolution applicant, yes.
The resolution applicant whose resolution plan have been accepted is subject to proper publication in the manner stipulated in clause regulation 6 of the regulations of 2016.
Lordship will record my objection to that. Lordship will record my objection to that in the sense that this will ultimately amount to reopening the very final judgment, which is not under challenge. Because this was a satisfaction recorded by way of an order in during the proceedings of the NCLAT. It ultimately
That
culminated
have
into the final
already-
order.
Mr. Sharma,
No, I'm just
no, Mr. Sharma. For the fact that you are standing in the court while I am dictating does not give you a privilege for making the again further submissions. I've already noted your
this
submission.
is out of my respect. I'm standing. Lord.
No,
I'm not
forget
sitting.
that. My question is now take your seat. I'm dictating the order. Don't disturb further. This court have given its anxious consideration to the respective submissions and have perused the materials on record. The materials on record as stated herein above makes it clear that on 12/11/2016, an amicable settlement was reached between the management of Maijan Tea State with the respondent, whereby the management of Maijan Tea State was required to make payment of the dues, make the payment of full back wages to the petition respondent with effect from the date of dismissal of the respondent till 12/11/2016. In addition to that, the management of Maijan Tea State was also required to take note of the service benefits of also make payment of the was also required to provide the respondent full service benefits, including retirement benefits, etc. Nothing has been provided to the respondent. In the meantime, on the basis of an application filed by one Seri Infrastructure P Limited, a proceedings have been initiated before the National Company Law Tribunal, Gauhati. A resolution applicant in the name and style of MSBRS Ventures Investment Limited had submitted its final resolution plan, which was duly accepted. And the said final resolution plan was also approved by the learned NCLT on 29/2018. Contemporaneously, the respondent also filed an application before the learned labor court, which was registered and numbered as Ms. Case number 1/2018. Sometime in the year 2021, as submitted by Mr. A. Sharma, the learned counsel for the petitioner, the objections were filed, stating inter alia that the said claim made on the basis of the award dated 12/11/2016 stood extinguished in view of the acceptance of the resolution plan by the learned NCLT on 29/2018. The learned labor court, however, taking into consideration that the respondent had no notice of the said proceedings which was pending before the learned NCLT. Passed the impugned order dated 19/4/2021. Holding inter alia that the petitioner respondent was entitled to an amount of rupees 1,85,000 so and so 175, as well as other fringe benefits which were required to be paid by the petitioner company within 2 months from the date of the order, failing which proceedings under Section 29 of the Industrial Disputes Act 1947 would be initiated. This court have duly also perused the judgments referred to by the learned counsel appearing on behalf of the petitioner. More particularly, the judgments in the case of Satish Kumar Gupta Supra, as well as Gyansham Mishra and Sons P Limited Supra. At paragraph number 105 to paragraph number 107, the Supreme Court in the case of Satish Kumar Gupta Supra observed that once the resolution plan is approved by the Committee of Creditors, it shall be binding on all stakeholders, including the guarantors. It was further mentioned that a successful resolution applicant cannot suddenly be faced with undecided claims after the resolution plan submitted by him have been accepted, as this would amount to a hydra head popping up, which would throw into uncertainty amounts payable by the prospective resolution applicant who would successfully take over the business of the corporate debtor. It was further mentioned that it was further observed that all claims must be submitted to and decided by the resolution professional, so that a prospective resolution applicant knows exactly what has to be paid in order that it may then take over and run the business of the corporate debtor. Paragraph number 105 to 107 of the said judgment being relevant is reproduced hereunder. This court also finds it relevant to take note of that in the case of Gyansham Mishra and Sons P Limited, and more particularly at paragraph number 102, the effect of a resolution plan being approved have been duly mentioned. Paragraph 102 along with its subparagraphs being relevant are reproduced hereunder. In the backdrop of the above proposition of law, it appears that once the resolution plan is duly approved by the adjudicating authority under section 31(1) of the code, the claims so provided in the resolution plan shall stand frozen and would be binding upon the corporate debtor, its employees, members, etc. In view of the said proposition of law, it is the opinion of this court that though the award was passed on 12/11/2016, and if the claim was not made in terms with Regulation 9 of the Regulations of 2016, such non-submission of the claims would amount to waiver of the claims This court is also of the opinion that the order dated 19/4/2021 can at best be taken as an order passed under Section 33C, capital C, of the Industrial Disputes Act 1947, thereby quantifying the amounts to which the respondent was entitled to. The question, however, arises, the said quantification of the amount of rupees so and so, along with other fringe benefits, by the learned labor court would not run against Section 31 of the code. However, it is the opinion of this court that the direction so passed in the order dated 19/4/2021, thereby directing the petitioner company to make payment within a period of 2 months, else proceedings under Section 29 of the Industrial Disputes Act 1947 would be initiated, runs counter to the settled principles of law as held by the Supreme Court, or Section 31 of the Code. Under such circumstances, the order dated 19/4/2021 which can be bifurcated into 2 parts, can be saved to the extent of quantification of the amount, thereby striking out the directions by which the petitioner company was directed to pay. Next. The next most pertinent aspect is as to whether the petitioner's claim, which arises on the basis of the award dated 12/11/2016, survives in view of the final resolution accepted by the learned NCLT by order dated 29/2018. As observed herein above, if the petitioner had notice about the publication so made, as was required to be made by the resolution professional in terms with Section 9, Section 6 of the regulation, the petitioner's right in respect to the award dated 12/11/2016 stands extinguished in view of the specific observations made by the Supreme Court in the above quoted judgments. However, it is the opinion of this court that if the publication so made by the resolution professional was not in terms with Regulation 6(2)(b), thereby not providing adequate notice to the petitioner who resides at Maijan Tea State, wherein the Assam Company India Limited was, that is the credit, that is the, what is that? Debtor, corporate debtor, was carrying on its business. Then in such circumstances, it can be held that the petitioner was stopped from approaching the corporate profession, the resolution professional to submit the petitioner's claim. This aspect needs an factual adjudication, and it is the opinion of this court that the said aspect can well be adjudicated upon by the learned NCLT Gauhati. Accordingly, this court therefore disposes of the instant writ petition with the following observations and directions. Number one, the impugned order dated 19/4/2021 states partially interfered with the directions by which the directions so passed in the order dated 19/4/2021. No, the factual adjudication as regards the petitioner's, the respondent's entitlement of an amount of rupees so and so, along with other fringe benefits in terms with the award dated 12/11/2016, passed in reference case number 4/2016, is not interfered with. Number two. This court, however, interferes with to the order dated 19/4/2021, insofar as there is a direction to make payment of the amount of rupees so and so along with the fringe benefits to the respondent by the petitioner company. The further direction so passed that if the said amount is not paid within a period of 2 months, else proceedings under Section 29 of the Industrial Disputes Act 1947 would be initiated, is also interfered with. This court, in view of the above observations, grants liberty to the respondent to approach the learned NCLT as regards the claim of rupees 1,85,000 so and so, as well as the other fringe benefits, if so advised. This court makes it clear that this court, for the sake of clarity, observes that it is only in the circumstance the publication was not made in terms with Regulation 6(2) or Regulation 6 of the Regulations of 2016, the learned NCLT would have the jurisdiction to entertain the instant application so filed by the petitioner, respondent.
Obliged, Your Lordship.
Case records turn to the learned liberator.
May I please, Your Lordship, my lord? My lord, before that, my lord, taking my 1 meter, my lord, it is in item number 13. So item number 13, my lord. So that is fixed for hearing. So my some urgency is very much required, my lord. I have to move out to Jorhat now. So that is why, my lord, I paid, my lord, any date, my lord, in Monday, Tuesday, whatever, my lord, lordship.
It comes on Thursday, my lord. It's a high court matter, so it comes on
Thursday,
Thursday.
okay.
Thursday. My lord, 12 is also, my lord, I have also some personal problem today.
Let's see when the matter.
Yes, sir.
You don't mention this.
Yes, sir. Lordship is allowed the 13 minutes. Item 13 has been.
You see what orders is required to provide us. Item 4.
Lordship, in last occasion, this honorable court has directed me to take the instruction for why the condonation delay was being dismissed of the reasons behind this. And I had communicated with my department, but there is no any instruction till yet. my lord. Morning time also I haven't called upon them. Regarding my affidavit on under section 119 2B of the Act. The petitioner department has simply revised the return. They have not statutory remedy of filing statutory return within the prescribed limit. That is the reason of our income tax department. In last occasion also, this case has been pointed out before this honorable court, and my lord has asked me to clarification of the stand why it has been
Paragraph,
paragraph page 99, my lord,
paragraph.
paragraph 9 of my affidavit in opposition, my lord.
Oh, the permissibility for in terms with 119 2B. Your case,
Lordship,
for condoning, isn't it?
yes.
It's on a particular fact that you were not aware. It's your case.
Yes.
And as you were not aware, therefore, you wanted to file your revised return.
Revised return.
And that is why you filed that application under the 119.
Right. For condoning the period, for allowing me to file the revised return.
But what is your ground? You say it was noticed that the principal ground advanced by the petitioner was subsequent realization regarding applicability of section 44A(DA).
Lordship,
Furthermore, it was noticed that a valid return for the relevant had been already filed.
Lordship,
It was further noticed that the petitioner had not availed the statutory remedy of filing the revised return within the period prescribed under the Act. Matter was examined in the light on upon consideration of relevant facts and the reports furnished during the course of examination by the concerned area, and upon examination it was concluded by the complainant that the petitioner did not satisfy.
Lordship,
Now, the fact that he has not filed the revised return
Lordship,
is for the reason why he has filed the application under 119,
Lordship,
Right.
isn't it?
Yes.
It is something like this, Mr. Gogoi.
Lordship.
You are supposed to file your appeal. Read appeal. And can you say tomorrow, when an application under section 5 is to file later on, saying for condonation of delay, I won't condone because you don't file the appeal.
Lordship, Lordship. I understand.
This is justifiable. Means, can you justify that? You could have very well said that this ground is not bad because of any other reason. But the ground which you are assigning is, as you did not submit your revised return, you cannot, the condonation application is rejected. Because of the fact that he could not submit the condonation, the revised return, that is why he has filed the application for condonation.
Lordship.
Exactly, Lordship.
Isn't it?
Yes.
Even otherwise, your lordship, that also been mentioned in the page 92 of the circular. It is from the perusal of the circular also, it is not been directory, not been mandatory. It is a liberal approach is there. It can again go.
No, it is not only a liberal approach, but the very basis on
Ah,
which your,
basis,
the reason which is being assigned here, because the rejection application does not contain a reason.
No, not at all.
So what you are now being stating in your petition and the affidavit is a reason which appears to be completely unfounded because of the fact that you did not submit the revised return. So we are not condoning the delay.
Because the time period of revised return was already over.
Obviously,
so we
that is
filed
that is the reason why you had
Exactly.
to move, file an application under 119.
19.
Lords.
Yes. And that is what for this circular is out by the CBDT.
We allow your petition.
Lordship.
Heard Dr. A2D, the learned counsel appearing on behalf of the petitioner. Dr. B.N. Gogoi appears on behalf of the respondent numbers 1, 2, and 3.
Lordship.
Present petition has been filed by the petitioner, assailing the impugned orders dated 6/7/2023, which have been collectively enclosed as Annexure 7 to the writ petition asked by the respondent number 1. Next. The brief facts of the instant case are that the petitioner is a medical professional having income from salary as well as profession. The petitioner filed his or her
His.
return for the assessment years 2017-18 on 27/7/2017. For the assessment year 2018-19, the petitioner filed a return on 19/7/2018. Next. For the assessment year 2019-20, petitioner took the benefit of section, while filing the return, took the benefit of section 44 ADA, all caps, of the Income Tax Act 1961, for short the Act, which provides for special provision for computing profits and gains of profession on presumptive basis. In the case of the petitioner that upon filing the return for the assessment year 2019-20, the petitioner became aware about the provision of section 44 ADA therefore wanted to file a revised return claiming similar benefits on the basis of section 44 ADA for the assessment years 2017-18 and 2018-19. As the time permitted for filing the revised return for these two assessment years ended on, what is the date? Can't be the same, Mr. Todi, Dr. Todi.
Lordship, it will be the end of the assessment year, that is 31st
Why
of
you are putting at paragraph number 6, you are putting the same date. Last portion, na?
31st March 19 is for 18-19. So
It was for 18.
for 18-19, for 17-18, it will be 31st March 2018.
And as the time period for filing the revised return for these two assessment years, that is 2018-19 and 2017-18 and 2018-19 had expired. The petitioner submitted an application on 16-10-2020 for condonation of the delay in filing revised returns for claiming refunds for the assessment year 2017-18 and 18-19. It was the further case of the petitioner that no action were taken by the respondents, for which the petitioner issued two reminders on 24/6/2022 and 24/3/2023. Pursuant thereto, on 30/5/2023, a letter was received, a communication was issued by the respondent number 3 to the petitioner, calling for additional documents of the clarifications and outlining the documents of the details required for processing the application of the petitioner. Petitioner claims to have submitted the necessary documents, thereby providing further explanation by the reply dated 8/6/2023. Subsequent thereto, on 6/7/2023, where's the document?
Annexure 7, Lordship.
Page.
Page 89.
Went there too. It's separate orders dated 6/7/2023. The petitioner's applications for condonation of delay in filing the revised returns were rejected by the respondent number 1 by merely stating that the rejection was in the light of section 119 bracket 2 bracket B of the Act of 1961. And the petitioner did not fulfill the criteria laid down in the board's circular number 9/2015 dated 9/6/2015 of CBDT, New Delhi. Being aggrieved, the petitioner therefore has approached this court by filing the present writ petition. Learned coordinate bench of this court by an order dated 8/4/2024 issued notice pursuant thereto, an affidavit in opposition has been filed by the respondents on 27/2026. Wherein, apart from denying the contentions made by the writ petitioner in the writ petition stated that the petitioner had originally filed returns in form ITR 1 and subsequently formed the view that the provisions of section 44 ADA of the Act of 1961 were applicable to him. It was further mentioned that the petitioner's application was examined by the department in accordance with section 119 bracket 2 bracket B. The Act of 1961 read with the CBDT circular number 9/2015 dated 9/6/2015. During examination, it was noticed that the principal ground advanced by the petitioner was his subsequent realization regarding applicability of section 44 ADA of the Act of 1961. Furthermore, it was also noticed by the department that valid returns for the relevant assessment years have already been filed by the petitioner. And the petitioner had not availed the statutory remedy of filing revised returns within the period prescribed under the Act. It was further mentioned that the matter was examined in the light of the circular number 9/2015 and upon consideration of the relevant facts, records and report furnished during the course of the examination by the concerned assessment officer, and upon such examination, it was concluded by the competent authority that the petitioner's case did not satisfy the conditions prescribed under the circular for exercise of powers under section 119 2B of the Act of 1961. It was further mentioned that merely by filing an application under section 119 2B did not confer any automatic or vested right to condonation and the power thereunder is discretionary in nature to be exercised in accordance with the statutory framework and the guidelines issued by the CBDT. When the matter was taken up by this court on 27/2026, this court made a pointed query upon the Standing Counsel of the Income Tax Department. What was the reason for rejection of the petitioner's application? Inasmuch as the ground for rejection had not been specifically mentioned. The learned Mr. B. N. Gogoi, the learned counsel, Dr. B. N. Gogoi, the learned Standing Counsel of the Income Tax Department, submitted that the instructions, that as per his instructions, what has been stated at paragraph number 9 of the affidavit. Record of dear, the said aspect having been referred herein above, record close. Is the reason for rejection of the petitioner's application. In the backdrop of the above, let this court consider the respective submissions on behalf of the parties. Dr. A2D, the learned counsel appearing on behalf of the petitioners, submitted that a bare perusal of section 119 2B of the Act of 1961 would show that the board, if it considers it desirable or expedient so to do, for avoiding genuine hardships in case or class of cases by general or special order authorized, any income tax authority not being a joint commissioner appeals or the commissioner appeals, to admit an application or claim for an exemption, deduction, refund, or any other relief under the Act of 1961 after the expiry of the period specified by or under the Act for making such application or claim, and deal with the same on merits in accordance with law. The learned counsel for the petitioner therefore submits that what is required to be looked into is as to whether it is desirable or expedient to do so for avoiding genuine hardship. Learned counsel further submitted that the board to the CBDT issued a circular dated 9th of June 2015, providing the parameters as to when the condonation of delay in filing refund claim and claim of claim forward of losses under section 119 2B of the Income Tax the Act should be an act, full stop. Referring to clause 3, clause 2, the learned counsel submitted that as the claim of refund upon filing of the revised return would be less than rupees 10 lakhs, the respondent number 1 was vested with the power of acceptance or rejection of such applications or claims. Referring to clause 3, the learned counsel for the petitioner submitted that there was an absolute bar put on entertaining a claim condonation application for claim of refund oblique loss beyond 6 years from the end of the assessment year for which such application is made. Further, the learned counsel submitted that no bar stipulated in the said application, in the said circular. The revised return is not being filed. The condonation application would not be taken into consideration. The learned counsel for the petitioner further submitted that the respondent authorities, more particularly the respondent number 1, ought to have taken into consideration that the said circular of the CBDT provides a liberal approach, more particularly as a claim for such refund would not require any payment of interest. Ms. Dr. B. N. Gogoi, the learned counsel appearing on behalf of the respondents, submitted that merely because of the fact that the petitioner have come to learn about the benefits of section 44
ADA.
ADA at the time of filing the returns for the assessment year 2019-20, the same cannot be a ground for submission of belated ground for permitting the petitioner to file belated revised returns. And as such, the Respondent authorities, respondent number one was therefore justified in rejecting the petitioner's application by the impugned order dated 6/7/2023. Well, in that regard, the learned standing counsel of the Income Tax Department further referred to the contents of the affidavit in opposition. This would have duly heard the learned counsels appearing on behalf of the parties and have perused the materials on record. From a perusal of section 119 bracket 2 bracket small b of the Act of 1961, it would show that the board had been granted the liberty if it is considered desirable or expedient for avoiding genuine hardships, thereby authorizing the income tax authority to admit an application or claim for an exemption, deduction, refund, or any other relief under the Act after the expiry of the period specified by or under the Act for making such application or claim, and deal with the same on merits in accordance with law. In exercise of the said power, the CBDT have issued the circular dated 9/6/2015 in respect to amounts below 10 lakhs. The Principal Commissioner of Income Tax oblique the Commissioner of Income Tax have been granted the power of acceptance oblique rejection of such applications oblique claims. In respect to amounts exceeding 10 lakhs, but not more than rupees 50 lakhs for any one assessment year, the Principal Chief Commissioner of Income Tax oblique the Chief Commissioner of Income Tax have been empowered any amount beyond 50 lakhs, the power is vested on the Central Board of Direct Taxes.
Notes.
It is further seen from clause 3. There is a clear embargo not to entertain any condonation applications, claim of refund oblique loss beyond 6 years from the end of the assessment year, for which such application or claim is made. It is further mentioned that the limit of 6 years shall be applicable to all authorities having powers to condone the delay as per the prescribed monetary limits, including the board. In the instant case, it would be seen that for the assessment years 2017-18, and 2018-19. The last date for submission of the revised return was where would be where submission of the revised return last dates are 31/3/2018 and 31/3/2019 respectively. Petition was filed by the petitioner on 6/3/2020, isn't it?
16/10/2000, 16/10/2020.
16/10/2020. It was well within the period of 6 years. What is the period? Not revised return. The last date of filing the return is what would be?
For
For
the revised return.
17-18 would be?
31st March 2018.
Yeah, end of the financial assessment year. Yeah. 17-18 will be to 31/3/2018
18.
and 31/3/2019.
19.
Not revised return.
Revised return.
No, we have to go as per. There'll be beyond 6 years from the end of the assessment year. End
Yes.
of the 17-18 would be
17/18 would be 24.
assessment year. What is the last date? Which will be the date for the assessment year? I think it would be
Assessment year
17-18 will be in
17/18 17/18 is the assessment year.
So it will be 31/3/2017.
No, 18.
Assessment year would be 18.
Yes. Previous year will be 17.
So it will be, it is not the revised return. Revised return will be 6 months later. See, you are to file your return sometime, just for example, now.
For
As of
assessment year,
now,
for assessment year
as of
17/18.
now, what is the present? Is it the assessment year 2026-27 or is it assessment year 2024-25?
Assessment year 26/27 is now, and return has to be filed by
No. Now, which we are filing the returns now,
Lordship. It's
is
assessment
what
year
is the assessment year?
26
2025-26.
26/27.
So 26-27, if it is, we are filing it now. So the last assessment year will end on 31/3/2017
No,
or 17-18.
no. Assessment year will end on 31st March 2027, next year. The period from 1st April till March is the assessment year. And previous year for during which our income has been has to be estimated is the,
Wait.
which may come to sections 3 of the Income Tax Act.
I always get confused with the financial year is better.
Partial lordship may come to section 2 subsection 9, which defines assessment year.
No. Assessment year 17-18 will be 31/3/2017. Here you are. Just for example, we are today filing it. We have 31st of July 2026.
26.
You are to file your return for your assessment year.
For financial year 2025.
Don't come again finance. We are not
Lordship.
concerned with finance. We are only concerned with assessment year. 31/7/2026 is the you are to file for the assessment year 2026-27.
Yes.
Therefore, your assessment year will end on 31/3/2026 or 27.
27.
You file within it
Within it.
for the previous year.
Yes. There are different time periods for different assessees. Some are to file in July,
is
some are in
okay.
August, some in October.
So the assessment will be done successively.
Yes. Lordship may find the definition of assessment year in section 2 subsection 9.
means the period of 12 months commencing on the first day of the April every year.
Yes.
It is the assessment year.
Assessment year. Now Lordship turn to section 3. Which defines previous year, which is also called as financial year.
As of income, huh?
Section 3, previous year defined.
Where any central act enacts that the income tax shall be charged for year at any rate. Income tax at the rate or rate shall be charged for that year in accordance with and subject to the provisions including so and so of the in respect to the of the
Lord.
previous year of the year. So you mean to say now to make it more simple, the assessment year is the period where you carry out the assessment. And on the basis of an income which arose the previous year.
Yes,
To make it more simple.
exactly. Lord.
Assessment year 31 the period for the end of the assessment clear line too. For the assessment year. For the assessment year 2017-18 and 2018-19.
1890.
The end of the assessment year would be 31/3/2018,
Yes.
19.
For 1718, it's 31/3/2018.
So how can it be again 18?
Lordship is saying about the assessment year.
So to the previous year. So assessment year would be different. No? It is the subsequent year.
When we say of assessment year 1718,
Hmm.
the
17-18,
when we say it is assessment
that
year,
is the financial year.
no, financial year will be 1617.
Understood.
Yes.
So therefore, financial year 16-17 would end when?
31st March
31/3/2017.
2017, right?
So the assessment year for 16-17 is 31/3/2017.
Yes.
Financial year is ending. So 1 year thereafter
Lordship.
is the assessment year. And accordingly for 16-17 will be 31/3/2018.
Yes.
So therefore, here for 17-18, it will end on 31/3/2019. 18. No, 17-18 will be 19. Oh, yes.
Slight confusion.
Yes. Because it would be ending on 31/3/2018 and 31/3/2019 respectively.
Respect.
Under such circumstances, in terms with clause 3 of the circular dated 9/6/2015, there was no embargo in entertaining the application for condonation of delay. In the backdrop of the above, let this court now test the reason assigned at paragraph number 9. In the backdrop of the above, let this court now test the reasons so assigned in the order dated 6/7/2023 impugned in the instant proceedings. In the impugned orders dated 6/7/2020 in the 2023, this has been made to the circular dated 9/6/2015. However, the circular dated 9/6/2015 do not absolutely prohibit, do not in absolute terms prohibit the condonation of delay. Except in a case where the period is more than 6 years from the end of the assessment year. Under such circumstances, the orders dated, the reasons so assigned in the orders dated 6/7/2023 appears to be vague and without any basis. Let this court now test these orders dated 6/7/2023 on the basis of the affidavit in opposition filed by the respondents, and more particularly, what is stated at paragraph number 9 of the said affidavit in opposition, which is relied upon by the learned standing counsel of the Income Tax Department. The reason so assigned is that the petitioners did not avail the benefit of submission of did not submit the returns within the time, revised returns within the time permitted. In the opinion of this court, the said reason is also without any basis and is a case of complete non-application of mind, inasmuch as it is for the reason that the petitioner had not submitted the revised returns within the time permitted. Petitioner had submitted the application for condonation of delay. In that view of the matter, it is therefore the opinion of this court that the orders dated 6/7/2023, thereby rejecting the petitioner's application dated 16/10/2020, and the subsequent reminders so submitted is without any basis and requires to be interfered with. I should remand it back.
Lordship.
Accordingly, this court therefore disposes of the instant writ petition with the following observations and directions. The impugned orders dated 6/7/2023 passed by the respondent number 1, which have been enclosed as Annexure 7 of the writ petition, are set aside and quashed. Number 2, the respondent herein, more particularly the respondent number 1, is directed to consider the said applications condonation of delay dated 16/10/2020, read with the reminders so submitted by the petitioner on 24/6/2022 and 24/3/2023, and the reply dated 8/6/2023. Afresh, the exercise be completed within a period of 3 months from the date the present, a certified copy of the present judgment is served upon the respondent number 1. With the above, the writ petition stands disposed.
Obliged.
What it is?
Please, Lordship. Lordship, petition is challenging the complete sealing of petitioner's office premises, my lord.
Huh?
Petition is challenging the complete sealing of petitioner's office premises, my lord.
Why?
Is a tax concern, there is
There was church lordship, and some documents and evidence were found whereby he was passing on fake input tax credit on the basis of fake invoices. And that was conducted on 1st of April 2026. And the documents and data that has been seized, it's still under analysis process. And Lordship, thereafter, only whatever discrepancy is there, we will issue DRC 1 under 73.
When did you seal it?
1st of April, my lord. 1st of April, 2026. My lordship will see first of, they have the power or not, my lordship will section 67, subsection 4, my lord.
We can keep the records for or seal it for 6 months, Lord.
Service tax act condition. It's in service tax act. Oh, good.
Section 67, subsection 4, my lord.
Where the proper officer not below the rank of joint commissioner has reasons that the tax has suppressed in transactions relating to the supply of so and so. He may authorize in writing of the officer of a central tax to inspect. The officer authorized under number 2, where the proper officer not be and so otherwise in others to the station or so and so, which in his opinion shall be useful for the purpose. Such seize or any or may himself search and seize. But where it is not practicable to seize the officer, so may serve on the officer or the custodian.
Now, my lord, section 67, subsection 4 says, if there is a denial, if I don't allow them to enter into my premises, then they can either break or seal it. If there is a denial, my lord, one, and there cannot be complete indefinite sealing, my lord. Suppose for temporary purpose, if I'm not allowing them, they can use force, they can seal it or they can break it, my lord.
So then,
Now, in this case, there is no, it's not a case of denial, my lord. They done the search, they issued seizure memo, they issued prohibition order, my lord.
teaser has been made.
Yes, ma'am.
Why you are sealing it?
Lordship, because some of the equipments or devices like the computer and other thing,
What are you doing, going to do with the computer?
because it's all online process and then that it has to be checked from the data installed in the
That happened this long time back. In the
Yes.
month of April.
April, Lordship, but Lordship may kindly peruse section 67, subsection 7.
Where any goods are seized under subsequent and no notice thereof within 6 months of the seizure, the goods shall be returned. This is for seizure. This is not for seal.
Lordship, some of it's in the seal process, but since it cannot be taken out immediately.
That is taken care of by the proviso to subsection 2. Provided that where it is not practicable to seize any goods, the proper officer or alia authorized by him may serve on the owner or the custodian of the goods an order that he shall not remove, part with, or otherwise deal with the goods except with the previous permission of such officer.
That has
is
been
being
done.
taken care of.
That has been done, my lord.
That has been done, Lordship,
Unnecessary.
because it involves around, Lordship,
Money,
Seven-
Mr.
seven,
Mr.
crores.
Mr. Chaudhary, money doesn't apply to this court. Maybe hundreds of crores, but you have to do it as per law. How can you keep on putting this particular thing on seal?
My lord,
First
moreover,
of all, I have serious doubts on the word seal being used out there. Because seal is, this has to be only where access to, but why has the power to seal or break open the power of anywhere? Have any judgments on this aspect, how it is being dealt with?
one judgment, Delhi High Court,
See,
my lord.
the power to break is subject to when you are
preventing it. Lord.
preventing.
My lord.
But why the seal is being brought in? Seal has to be is a separate power from that of the power of seize or search or break open. Sealing is done when? Sealing is a very serious power.
On
Any
that, on,
judgments?
it is not on that line, my lord. It is a line in the Delhi High Court judgment which says they cannot completely seal it, my lord. It will not help in, it will not. I got your lordship's point.
I have serious doubts. You can't exercise sealing like that. Is what? Why the word seal has been to seal or break open? The business premises be sealed. Yes, Mr. Mishra. They're not prepared properly.
My lord. That I missed
You
this seal part.
you
I'm
have
my
now
mistake.
got yourself becoming expert in this cancellation and whatnot. Expert in which? Cancellation and in respect to GST, which are the two expertise?
Not expertise, my lord. I'm just doing it. I'm not expertise, my lord.
No, in which thing you are doing it more? One is cancellation. Then we see you doing
73
consolidated
also.
stokos. Then which else? What are the type of GST matters you are doing?
Summary of SOCOS notices, summary of SOCOS
73
notices,
section.
Summary,
then
proper notice is not in
invocation of section 74 in proper.
24. All these things you are doing.
My lord.
Now what, is this your first case on sealing?
First case, my lord.
Okay, so you're not prepared.
So
This
this,
should have been prepared. That
I'm-
this is not the first time they are sealing it, isn't it?
yes, my lord.
Power have to seal. Hey, consider seal with some commentary. Put that all over and say, oh, you can adopt it. Let us see what Dr. Saraf has put in his book. I see a book here. Power of sealing. Doubts on the power of sealing. If a search operation under the Act reveals affected articles in a locked room, Almira so-and-so, 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 seal the door of the premises to prevent the text. There, the commentary is if a search operation under the Act reveals suspected articles in a locked room, almirah, electronic evidence or other receptacle, and the person in charge of the area denies access, the authorized officer may, with due recording in the file, either seal the door of the premises to prevent the taxpayer from accessing secreted articles liable for seizure, or break open the almirah so and so. So, your complete is your seizure complete? If your seizure is complete, you can't keep this particular property under seal. That is what I understand. You that.
Even now, there is no order for sealing also. Lordship will, there is no order also.
What?
Lordship they have issued seizure, then they issued prohibition order.
Wait.
Page 37, my lord. It is the prohibition order, my lord.
This has been issued under section 67(2), Lordship provide.
It's okay. That is a seizure. Then this is seizure.
My lord,
Yes, ma'am.
37 is the order of prohibition. my
Witness
lord.
so and so present GST intelligence. Where is the sealing? No order.
No order, my lord.
Lordship, in this Annex D, page
They
43.
just pasted this.
Let us see the rules. GST. Yeah.
139, my lord.
What? Huh?
139.
139. Inspector and search and seizure. So here there is nothing mentioned about sealing.
Yes, my lord.
The sealing seems to be a very temporary measure, thereby stopping him from assessing the particular premises in order to so that the evidence is not lost. Mr. Chaudhary, APS. Therefore, there is no order of sealing. Where is your order to seal?
Lordship, page 43.
That's
they have
such,
pasted.
Whereas in exercise of so and so, details of so and so, in presence of scrutiny and so, I have reasons to believe, therefore in exercise of hereby shall not cause to remove part of so and so. It's okay. Then sealing is where?
Lord, page 43, my lord. Lordship will see they have pasted this thing in the shutter of the office, my lord.
Huh?
That page 43 is that.
Ah. This is not possible.
Lordship, if Lordship
It's
looks
not
into the
permissible.
forms,
And
Again-
there's no reason as to why you are doing it. Is it on the basis that he is trying to access to that? You have already seized it. Once your seizure is over, then what do you mean? You have also given it the custody of the materials to somebody.
yes, to the petitioner himself.
You have given him the custody, but you have asked him not to enter. Not permissible.
Because Lordship, there are all electronic devices and other heavy equipment which was not possible since the intelligence team was going from Guwahati at Karbi Anglong. Lordship, it was not possible them to bring it back on the same day. So the order of prohibition was there.
4 months.
Yes, almost 4 months, Lordship.
How is it possible?
Lordship,
That's
one thing
Karbi
is,
Anglong
while going through it before your lordship, as per the rules, there has to be an order of prohibition. And the petitioner has annexed just the pasting of in the shutter. Lordship, there may have been a order of prohibition as per form.
Page 37, it is there, page 37. Page 37 is the order of prohibition, my lord.
where
Page 37, my lord.
I have reasons to believe that certain are liable to confiscation and therefore as far so and so. Exercise of power, I order that you shall not cause any remove of part with or otherwise deal with this. This order is there. Well, but how do you prohibit somebody? On one hand, you have handed over the property to him, but he is prohibited from entering there. How is it possible? Not possible.
Lordship may allow us sometime. We'll bring all those devices to the intelligence office at Guwahati, Lordship. We'll
What devices?
there
You
are
have a desktop. No, wait.
yes.
What are the devices? You have a desktop, a black laptop,
Yes.
laptop,
yes.
gray laptop, laptop. You need the printer also is there. Something is inside the printer. Files, battery you require, the inverter you require, files, air conditioner, refrigerator. Why are you attaching the refrigerator? My goodness. Tax has no business to do all these things, the air conditioner. How is the air conditioner hiding something? It's a complete non-application of mine. As regards the laptops which are there as well as the desktop which is there, you need the hard drive only.
They can take backup, my lord.
You take backup hard drive only, nothing more than that. You don't require anything else. Does it take 3 months for that? Ah, this type of thing cannot be permitted. Anyways, let me do. It seems that I shall be the first one to write on seal.
Man.
So let me look into it as, or you help me out.
I will go through the different ways.
You go through it,
Sure, man.
pick it up and next Tuesday and dispose it of
My
at
lord.
2. Okay.
My lord.
In the meantime, let us look into, because the power of seal,
My lord.
it seems to be only an emergent power, only for the time being, because so that if you don't seal it, just for example, in a case where you go there and he is not allowing you to go inside. Therefore, it says in the same thing,
Break and
so
set.
do not allow you to go inside. Then you, however, you immediately you break it. You go inside. After you go inside, then you think that you found certain things and there is a chance that he will come and temper. Then you seal it. This is only. But the moment you have done the seizure,
It's not.
what do you mean? Isn't it?
My lord.
So get away from this cancellation of RIA.
My lord.
Now go into search.
My lord.
Okay. Matter having been significantly heard, is this matter on so and so next site A.
Lordship, can it be on 6, Lordship? Can it be on 4?
Six too many. Mister,
Lordship, on
Mister,
4.
Mister can dictate the judgment, right? But the fact that is I'm not getting help from both of you. And I'm also handicapped, having not looked into many other aspects. I don't want to deliver the judgment to be the first one to deliver on this power of sealing. The sealing appears to me to be very limited. But then also let us explore. You look, and you look, and I.
No, but Lordship, on 4, the entry tax cases are going to be listed before court, number 1. That's why, let it be on 5th, Lordship.
There's entry tax cases would never happen, I tell you. Whenever those entry tax cases are taken up by the division bench, the Chief Justice out there, he immediately gets elevated to the Supreme Court. So that would never happen, don't worry. Because I was one of the petitioners. Eh?
Yes, Lordship, and I
I
have
was a
experienced
counsel out there for the last so many years. All Chief Justices. You see, Justice
3,
Bopanna.
Lordship.
Justice Bopanna had
Yes.
heard it. Justice Dhulia had heard it. Then you have Justice Bishnoi heard it. Almost means judgment to be pronounced. Then all these things happen. Justice Mehta heard it. So all these Chief Justices go.
Gets
This is a
elevated.
thing which is a stepping stone to go to Supreme Court. Okay. So don't worry. That it won't happen. And we need it only at 2 p.m. Your presence.
On the last occasion when
What happened to the Nazir?
my lord, Nazir also penalty was imposed.
Much.
His pay was reduced to 14,820
From
from 19,750 with effect from 21/11/2011 for 3 years. Yes. Here the punishment is
Page 123.
1 second.
I was imposed 2 punishments, my lord.
Here punishment is for 3 years, my lord, but the basic pay is different. My lord, one aspect I'd like to place before your lordship, my lord, what I have seen from the records. My lord, as of now, the contention of the petitioner before this honorable court is that, my lord, the learned presiding officer did not mention about the execution case number in the order. That is 21/7/2011. And because of which, my lord, the petitioner was unaware about the connected case, that is the execution case number 36/2011. My lord, sorry, my lord, execution case number 6/2010. And as because he was unaware, he could not inform the presiding officer. My lord,
where is that order? There is an order.
that is the finding of the, yes, 21/7
page.
page
21/7.
Yes, my lord. I'll just show my lord. Page 79.
But this order was passed in the suit.
This order was
Understand?
passed
No,
in
this is not an order passed in the execution.
No, it was passed
You
in,
see, on the other hand, kindly come to page 48.
yes.
EO is on leave, DH is present, judgment
This
debtor
is in
file petition
execution.
under so-and-so along with letter of the advocate praying for stay of the execution, fixing so-and-so for hearing and necessary order. On 3 years had submitted a copy of the order with a demand passed by the Honorable High Court in so and so by which revision has been dismissed.
Yes,
And the earlier interim order
order
of the stay has been vacated
vacated.
in petition filed by the judgment debtor
Decree
for
holder.
issuance of writ, delivery of possession of the
Decretal room,
room with the help of the Nazir
Nazir.
and armed forces.
Yes,
Heard. So this is the first petition filed for armed forces. Okay. Heard, Peru,
CR,
Peru CR. So and so
including the
action
order,
initiating the act,
previous orders.
huh?
Yes, yes, my lord.
Including,
Heard, then permit
No, including the order dated so and so, so and so, so and so, being satisfied,
satisfied.
I
and
allow
now
the,
the petition. So
petition.
armed forces is permitted.
yes,
Then on CR, so and so CR is put up today, sealed petition number filed by JD for recalling the writ in as much as so and so as the year. In the meantime, call for the report of the year. Now on when did the execution happen?
in it,
10,
Huh?
10,
in it,
10/8. So on that day, the filed by the JD
judgment, yes.
for
When-
recalling. Now,
When the execution happened, they complained and below those things happened.
now who filed this application on this page?
Mid-J
This thing
case,
at page 79
page 79 by judgment debtor, my lord.
and the
This
judgment
is Miss case, Mid-J case number 36/2011.
Huh?
So 36/2000, this was filed for stay of the execution.
No. Here it is filed in the suit. Page 79 is a application filed in the suit.
Page 79, yes, suit.
An application filed in the suit. The order 9 rule 13 application.
Correct, my
which
lord.
was filed in the
707, yes.
And in that suit, the court issues notice on 21/7/2011 and the execution of the ex parte decree so and so remains stayed until disposal of the petition or objection.
True.
Decree, ex parte decree dated so and in so
Shall
and
remain state,
no date, nothing mentioned.
fixed on so and so for objection and hearing.
Objection and hearing. So this was given on behalf of so and so. Now this application was filed on 10/8 by the judgment debtor.
Yes,
And is this the judgment debtor is the same? No. Because he had already filed another application. Page 48.
48,
is decree holder, my lord.
it is by the decree holder.
No, judgment debtor.
No,
IDC,
no.
23/6.
DH, sin petition number so and so filed by the DH
23/6.
23/6 PO. Yes, my lord. PO is on leave. DH is represented. JD filed white petition along with letter of advocate praying for stay of the execution. 23/6 fixed on so and so for hearing and order. 593. My lord, there were many judgment. In fact, defendants were more than one. So I'll have to just check who filed this 593. Plus, as I have seen the records, my lord, by this judgment debtor whose shop was evicted, my lord, he has filed this Mid-J case number 36/2011 in title suit, my lord, wherein page 17 an order was passed.
This is the next again another on 10/8/2011 another.
Yes,
All sin petition number 359/24.
yes,
Uh,
filed by the judgment debtor for,
under section 151 for restoration of possession.
yes, this was, I think, another judgment debtor. He filed the CRP. Anup Kumar Paul or something. Anup Kumar Paul, he filed the CRP.
There are total 11 defendants, my lordship. So Anup Kumar Paul has filed the CRP, it got dismissed. This Mizze was filed by one another, that was Sopon Dev.
Sopon Dev,
My lordship.
Sopon Kumar Dev.
Sopon Kumar Dev, my lordship.
So
And-
this page 79 was by the Sopon Kumar Dev. So their entire case was that, my lord, since there was no mention of the title execution case number here, so the petitioner was unaware, and accordingly, my lord, he could not inform. There is a big role of the Nazir here also, my lord. I have seen the records, my lord. Nazir has played a very, my lord, unwanted role here. So that's why he got penalized, my lord.
No, he should have been chucked out from the job because I know this is how it is happened.
No, that's true, my lord. Lordship is absolutely correct.
Mr. Das, the person concerned, the person had nothing to do. It cannot do anything.
But there is
These
something, my
things-
lord. There is
The
something.
Executing court, the executing whatever may be, first of all, is the miscase. Miscase is in the suit.
Correct.
Here, it is a apparent mistake on the part of the court not to, what do you stay? You stay the decree. You don't stay the decree. See, in an order 9 rule
will
13
stay of
application, you
execution.
stay the execution.
Correct, my lord. Correct.
Here, execution proceedings should have been mentioned here.
Your lordship is absolutely correct.
Now,
But
if you, because you see, LEC order for 41 rule 5. You don't stay there, yeah. This will come under order 41. Mr. Jain, let us take your expertise. You have been into a lot of execution proceedings. What is stayed? In an order 9 rule 13, you don't stay the judgment or the decree. You stay what? You stay the execution. See the order.
yes, my lord.
Judgment stays in the appeal, not under order
Stay of
9
the
and
court,
13.
which, well, here also in our case, my lord, the execution was stayed. No.
Stay the execution of the ex parte decree.
Execution of the ex
So
parte
it
decree.
was therefore the duty of the court in title suit number so and so. There is no date mentioned.
Lord,
for the decree.
I can satisfy.
There is no date mentioned.
True.
Mention about this. You don't stay the decree. What you stay is the execution. of the
Execution, my lord. Correct.
So execution, if it is being filed, obviously that must have been mentioned out there in the application. So therefore, what you stay is the execution proceedings.
Correct, my lord. Lordship is-
Therefore, order 41 rule 5.
Yes, my lord. I am reading, my lord. Stay by court, which passed the decree, where an application is made for stay of execution of an appealable decree before the expiration of the time allowed for appealing therefrom, the court which passed the decree may on sufficient cause being shown, order the executions to be stayed. No order for stay of execution.
Execution is filed.
Yes,
Then only you stay the execution.
correct, my lord.
So you have to stay the proceedings.
Correct, my lord.
You have not stayed the proceeding. You should have stayed the suit, the execution proceedings. This is the manner in which you should have done it.
True, my lord. My lord.
Now here you don't.
Look, I
mention
cannot
that
go
you-
into, I cannot go into the order passed by the
No,
presiding officer concerned.
no,
my
the
lord.
thing is like this. When a judicial officer makes a mistake,
Correct, my lord.
this is an apparent mistake by the judicial officer also. Because he should have been more careful, categorically mentioning that particular date. Now for that, you are imposing a penalty upon another person on the basis of an ambiguous order. Permissible.
My lord, it's not the, my lord, that is not the, what the record says, my lord. Allegation was that you were aware of passing of this order, but you did not bring it to the notice of the presiding officer. Now, question arises whether the petitioner was aware or not. Two reasons he cited for not being aware. Number one, there is no mention of the execution case number here. So that's why he was never in a position to know that this order was passed in connection with the execution. Although this Mijje case number 36 of 2011, in the pleadings as well as in the prayer, both the title execution case number as well as the suit number was there. Well, that is a separate thing altogether. Now, another reason cited by the petitioner is that, my lord, the advocate concerning the judgment debtor did not take steps. That is another reason said that they also did not take any steps, so I could not know. Now I just place the records before your lordships. You know, three pages I have marked. My lord will kindly have a look. First is the deposition of the advocate. He categorically stated the date on which he took the steps. Cross was done, that evidence was never rebutted. Second is the deposition of, my lord, N.K. Taran. It has got relevance. I have flag marked. Lordship will have a look. Third is the deposition of the petitioner himself, wherein he categorically deposed before the inquiry officer that after 2-3 days from 5/8/2011, but before 10/8/2011, that is the date of execution, he was aware about this order, his own admission. Going by his own admission, my lord, in my humble submission, we are not required to go into proving the allegations. He very candidly deposed, my lord, the last flag. In a departmental proceeding, in my humble submission, my lord, what we are concerned is that whether there is some evidence or not.
After 2-3 days from 5/8/2011, but before so-and-so have gone through the case record of miscase and found that there is a stay order, but there is no mention of title execution number in the said stay order.
But what does it mean? That reason he has said, fine. But he was aware that after 2-3 days from 5/8/2011 till 10/8/2011, that before the date of execution, he was aware about passing of this order.
Yes.
By the
Yes.
court. So it was his responsibility. I'm just placing, it was his responsibility to inquire with the presiding officer that this order has been passed in connection with which execution case. Number one. Then Taran's evidence, your lordship will kindly have a look. He also said something, my lord.
What did he say?
And the evidence of the advocate. They said they have.
Let's see the advocates.
Yes, my lord. My lord, flag mark, blue flag mark, I think, my lord. Deposition of Dhruva Kumar Saha, advocate. He has said that we have taken steps.
My father's name is Makhan Paul.
No, it is the my lord, deposition of Dhruva Kumar Saha, PW4. Page number 3.
Yes.
On the event of submission, lordship Scotland.
this advocate categorically says that he was not the advocate.
No, regarding taking of steps,
No, wait, he's not the advocate.
he was not the advocate in execution.
No, kindly, yes, he's not the
But
advocate in
this
the
is-
execution. Wait, what
No.
he says. Kindly see page 2 of his
Yes,
deposition.
yes.
Cross. I
Cross,
am one of the senior members of the district so and so. Since so and so I am practicing as an advocate, I am well conversant as a so and so is to submit on being engaged by another party, and the same is to be submitted in the concerned court. So and so Bhattacharjee is a junior advocate and practicing under me. Petition number so and so exhibit D was prepared under the instructions of my client, and the same was submitted in the court after being identified by me. I am not an engaged advocate of either party in title suit number so and so. I do not know whether any petition is required to be submitted in the execution case whenever any stay is granted in this case arising out of an execution proceeding. Neither myself nor my junior submitted any petition in the execution proceedings. It is not a fact that I have prepared the complaint so and so of so and so. In Exhibit D, there is no mention about the allegation whatsoever in the complaint so and so. Petition number does not appear any time when it was submitted before court. Exhibit E is the petition. On the event of submission of so and so, the learned Munshi an order and thereby stayed it so and so and fixed the matter for objection hearing. On so and so steps have been taken on behalf of my client by Christie affixing court fee bearing so and so dated demand, and the said Christie was identified by me. But those notices have not been issued upon the opposite party as the case record reveals. I do not feel that if been
notice of
dated
miscase.
served upon the incident of this year, I have my personal self-person where I
Yes.
used to come to the court regularly, certified my homestead so and so. Instructions of the year I brought Sandeep and produced before the learned year for giving statement. Both so and so while Sandeep Dev submitted petition before the concert and before the learned district judge, no copy was certified of the stay order. Next with those complaints, I have nothing to show in the documents that I had made communication about the stay order passed it here to the concerned dealing assistant, but I made verbal communications. It is not a fact that I did not make a verbal communication to the concerned dealing assistant about the stay order.
Yes. Then page 4 also, my lord. It is not a fact that at the time of execution of the writ of possession in so and so, the Nazir Nazir had no knowledge about the stay order passed in Mijje case number so and so. It is not a fact for the negligence on the part of my client and myself being engaged as lawyer of my client for not taking proper steps timely. The writ of possession in so and so was issued. So from this evidence, my lord, at least this is established that they took the step.
Is the steps part of the record?
Uh,
Has it been exhibited?
so and so. Identified by me, my lord, perhaps it is exhibited, so he identified. My lord, that I'll have to check, my lord. But he very categorically said that his submission also, his statement also is an evidence, my lord.
Huh?
He very categorically state before the inquiry officer that he had taken the steps. On so and so.
He need not. During cross it came up.
No, cross is by this.
Never said in his chief.
Yes. No, in chief, he said the order of stay was communicated to the execution branch of the chief Munship number 1 accordingly.
Where?
The first page, my lord. On the second paragraph. On 21/7/2011, the learned Munship number 1 Kachar, Silchar admitted the said miscase number so and so and white order stayed the execution of the ex parte decree in so and so till disposal of the miscase number so and so. The order of stay was communicated to the execution branch of the office of Munship number 1 accordingly.
Where is the evidence? Because he later on said, neither myself nor my junior submitted any sub petition in the execution proceedings.
No, this is in the, no, what, I'll just convey.
No, the question is
What,
like this.
what he says, what he comes before the inquiry officer and he deposed that we communicated it, number one. Number two, it was in the order in the Miss J case. They communicated to the execution branch. In the cross of Taran, he said that we took steps on 27/7/2011, the advocate. And he also
And
said
the
that,
steps have not been brought. Have not been put in
no,
evidence.
this was, this evidence of him that he took steps was never controverted by the, either by Taran or by the petitioner. This itself
No,
is an evidence.
This he said in the cross.
Well,
that he
even
took
if,
steps. In the chief, he did not say anything.
even if it
But he
is-
did not submit any application in the title execution. And how did he inform the execution branch? Tell me.
applicant petitioner himself said that prior to execution,
He knew.
he
it.
was, he was aware.
He knew it. But he did not
That
know.
itself is an evidence, my lord.
Yes, so what is the evidence? That he has seen this order, but the order did not state anything.
And
as
is it
to
not his
which
responsibility?
execution.
Just for a query, my lord, he has seen the order. Is it not his responsibility to take the order to the presiding officer? In what connection?
For a lawyer, it's very good to say that. You know how the judges function, huh?
My humble submission is that it's like enquiry has been completed, my lord. The enquiry officer recorded the findings, disciplinary authority has given a findings. My lord, scope of judicial review on my humble submission, my lord, it's not that enlarged to appreciate this as an appellate authority.
No, it's not. I'm only on the question as to regard those
Because
two
your
orders.
lordship is to see only whether there is relevant evidence available on record or not,
No,
to come to a conclusion.
There is a perversity on the evidence. On
Yeah.
appreciation, perversity is there.
My lord, the statement
If there is
itself
a
is an evidence.
perversity, normally we do not, but if there is a perversity, first, the order does not say anything. It was the duty of the judicial officer to
No,
do
that, my lord, keeping aside that thing, my lord, keeping aside that aspect of the matter, my lord, there are materials, because the statement of the advocate that I took steps and the petitioner failing to establish that he did not take steps leads to the conclusion applying the
He
principle
himself
of
said that
preponderance
he
of
did not take-
probability.
He did not take steps in the execution proceeding.
No, it's, my lord,
So,
if he takes steps in the miscase also, if he takes steps, the petitioner will be aware. Because in the petition, the MJ case number so-and-so, in that petition, in the pleadings as well as prayer, both the title suit and title execution, and that petition was put up by the petitioner himself. That petitioner was put up at the time of, before the court, presiding officer by the petitioner himself. So, my lord, my humble submission is that it is not a case that there is no evidence. There is some evidence to show the negligence on the part of the petitioner.
yes,
And-
rightly. I would say it to be a negligence, but does negligence amount to major penalty? My question is this.
My lord, if a my lord, to ascertain with
Negligence
what
has to
penalty,
be of culpable nature for imposing the major
I
penalty.
am in agreement with your lordships, my lord. If the penalty, my lord, taking into consideration the negligence depends upon the injury cause.
No,
In my humble submission, my lord.
then you show.
If a
as
negligence-
to whether any disciplinary action has been taken against that officer, the judicial officer.
My lord,
Because he was the responsible, he was the person who passed the order. First, on 23/6/2011.
after passing of the
Nothing is
order by the
finished.
presiding officer, the file, because he also reports that after filing of the, after passing of the order, file go to the petitioner. So we
Let us
are,
give
we
you
are
a-
blaming the presenting of
Mr.
presiding
Das,
officer
let
that
me
you
give a
haven't done
very-
this.
An example of that. We have out here in the rules that all similar matters are to be placed before the same court and all. Whenever there's any similar direction, you have it mentioned out there, or any other similar matter in the filing section is there, no? Okay. Now, I pass an order of stay in a particular matter, or I decline the stay. I dismiss the petition. The same person again files. I don't know, because I can't remember each and every person's name. Matter comes up, it is being placed by them. They don't look into the aspect pertaining to that, or do not check it out as to whether the same person has filed or there is somebody else who files that particular application to that effect, or does not mention in that particular column that there are similar matters. I pass a stay now against the matter which has been dismissed. Whose responsibility is? Is it the clerk who has in the filing section not put that and take a disciplinary action against him? Or is it the case of the lawyer? Misled the court.
So that is a.
Who has misled the court? So therefore, the question you has
It's
to
an
be,
example, my lord.
that has to be looked into in that angle.
My lord, lordship is correct. Since it's an example, my lord, it is a very larger issue. The question that has been posed, whether the lawyer should be penalized or the clerk should be penalized. Your lordship is absolutely correct. The lawyer has done some mischief.
Maybe that particular lawyer is also not there.
He may not also know, my lord. He may not be instructed. Lord,
He
that
may
is,
not be there.
that
So
is
he
one
has-
aspect of the matter. But what I am trying to, my lord, convey to your lordships is that, my lord, admittedly, my lord, there was some evidence and there was negligence on the part of the petitioner. Now the question is whether major penalty should have been imposed or minor penalty. That will depend upon the fact that the injury caused. Why I am saying so, my lord? As no, one second, my lord. Because of this negligence, consequence lordship will see. What happened? Despite there being a stay order passed, that shop got, my lord, evicted. So this has got bearing, and this penalty, the other person also, Mr. Taran,
No,
he has
the
also.
Judicial officer. I'm saying about the judicial officer. What happened to him? He was the person who has passed these two orders. Isn't it his
Mistake of,
responsibility?
my lord,
Doesn't
even,
he-
my lord,
No, no,
even,
no,
even,
Mr.
even,
Mr.
even
Counsel,
if you.
doesn't he have to own to his fault? His mistake, it was there. It came within a passage of only 10 days.
But with all due respect.
And then the Munsif doesn't have so many matters for that. And he is the only executing court. If you are not aware, the only executing court will be that court.
Milord, at present, Milord, we are concerned with this petitioner, Milord. We are concerned with this petitioner.
No. When you are saying about the magnitude, when you are saying about the magnitude which has happened, a negligence which affected somebody, the negligence qua him may be less. It may also be, you may put it to the negligence of the solicitor.
Lord,
You
Lord,
may
so-
put it to the negligence of the court master who has placed the file. Why he has not, what is the requirement? Whenever there is an application filed under in the suit for for execution, the first order which is required to take the records of the decree. Isn't it, Mr. Jain?
Milord, here, the
Where-
secretary,
where-
I'm
where-
sorry, I'm sorry.
Mr. Jain, whenever an execution proceedings, an execution application is filed, the court first passes the order for taking the records of the suit.
Yes.
That's the first requirement. Did he pass that order? And if he had passed the order, this thing would not have happened. He did not pass that order.
We'll take original record and the.
This is how it is done. This is the mandate of the civil rules and orders also. That whenever you file an application, then that matter is being taken up. The moment that is there, the court judge would know.
I am not on that, as of now, Milord, Lordship has seen, Milord, I am on a different footing, Milord.
No,
No,
my
I'm not
question,
saying-
Mr. Das, you have to understand one thing. This is This is an understanding what needs to be done. For a thing which is a case of mere negligence, qua the petitioner, a culpable negligence in qua the Nazir, equally a culpable negligence for the judicial officer. Should the petitioner be imposed with a major penalty? This is the issue.
But so far as the quantum of penalty is concerned, my lord, it is your lordship's discretion, my lord. So far as quantum
Not
of
only
penalty is
major,
concerned, my lord,
major along with minor under one
so
survey.
that I can satisfy, my lord.
It's okay.
Two penalties, major, minor by the same order, that I can satisfy. There is a Supreme Court judgment to that effect, my lord. But so far as the
disproportionate-
first point is concerned, say regarding the negligence, my lord, it's an apparent position from the records itself that there was negligence on the part of the petitioner. So far as quantum of penalty is concerned, my lord, I am not insisting on that. Lordship can take a call on the quantum of penalty, my lord. I am leaving it to your lordships, my lord. It's my duty to place the records before your lordships. I have shown the records. I have tried to satisfy your lordships. That I have
No,
done.
I will touch on that. I will strike out the major, keep the minor.
Lordship will take a call on that. I am not, my lord, I'm not going to that far to, my lord, cause problem for the petitioner, but that your lordship will take a call. But that is on the count of negligence. That is my submission, my lord. So far as the other contention of the petitioner is concerned, that by the same order, major minor penalty imposed, my lord, there is a Supreme Court judgment, my lord. In fact, two judgment.
One judgment will do.
I don't. I hope this will, my lord, satisfy your lordship. Itu could get more copy to Punjab. Because this lordship will kindly see the penalty order once. Penalty order.
113. 113.
What did he say? In Kulwant Singh Gill, what did he say?
I'm sorry, my lord. I'll just show the paragraph. In fact, the next one your lordship can take up wherein Kulban Singh also has been referred, my lord. That is Rajkumar Goel. Para 2 onwards, my lord. Penalty order to go full. আমার নোটিং করা আছে এইটো 123 123
Where does it say? That there you can impose
No,
minor
no, it
and
doesn't
major
say.
together?
No, that's why I wanted to take your lordships with the penalty imposed.
No, no. What was the penalty imposed was?
It says
No, it was the
reduced.
no, what was the contention out here? The contention out here is, though it was a minor penalty, but the penalty has been imposed in such a manner, it takes the color of major penalty. That's the issue.
Cumulative effect.
What do you mean? That
Here,
was
my lord, the
issue.
penalty imposed upon the
But
petitioner.
it doesn't say that
No, no.
these laws.
No, I'm
Mr.
sorry, I'm so
Das-
sorry.
Mr. Das, you made with great assertion that a minor and a
No, 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 no.
major penalty can be.
My lord,
together.
I'm extremely sorry if I have conveyed in that
Yes,
manner.
You did.
Yes, my lord.
My lord, lordship,
My
I'm,
lordship,
my lord,
Mr. Das, don't make this type of submission.
no, I'm sorry, my lord, I'm sorry.
Nowadays, after the Devdutt episode, Whenever you refer to a judgment, I look it twice.
Milord,
Because it's very difficult for this court to believe it. You just now say that you can impose the major and minor
No,
together.
I said,
You
Milord,
just say-
Milord, I understand, Milord, I said in the context of, that's why page
Don't
123.
change your words now.
No, Milord,
He has been stating categorically that you see you in one department, you cannot impose two types of.
Milord, I take back my words, Milord. I'm sorry, Milord. I take back my words, Milord. Perhaps, Milord, it's my mistake, Milord. Not perhaps, it's my mistake. I'll just take your lordships to the penalty imposed. I wanted to say before your
Not that.
lordships.
My question here, we are.
It's not a
concerned-
minor
no,
penalty.
In the instant case, we are concerned with, there are two forms of penalty. What are the two penalties, madam?
Major penalty and minor penalty. My lordship, here two penalties on the ground of negligence, my lordship. One is reduction to the lower scale time of pay, which is major, and another is he will not earn increment of it. This is minor. So both are subset under one heading, which cannot be done.
Lordship will kindly come to page 123 for a moment of the
Yeah,
repetition.
repetition.
Lordship will kindly have a look at the penalty imposed.
My lordship may start with
120.
122 last paragraph.
123.
For a second, 122 last paragraph.
To time I have put it.
Yeah.
Page 123.
So and so.
Accordingly, so and so is reduced to a lower time scale of pay from basic pay so and so to basic pay so and so for a period of 3 years with effect from 21/11/2011 with further direction that he will not earn increment of pay during such period. This is with cumulative effect and it is a major penalty. And on expiry of the period, the reduction will not have the effect of postponing his future increments of pay. The contention of the petitioner is that he will not earn increment of pay during such period is a minor penalty. It is not in view of the Supreme Court judgment, my lord. Lordship has seen here the Honorable Apex Court in very clear terms, para 10 and 11. So since it's for 3 years with further direction that he will not earn increment of pay during such period means it's with cumulative effect. The moment it comes to cumulative effect, it becomes a major. So there are no two penalty in the impugn order. In fact, the other person also has been imposed the same penalty. Taran.
Now you tell me, if I hold him to be negligent,
Yes,
what happens? Not gross.
the conclusion, no, Milord, what normally the law is that the matter goes to the disciplinary authority, he takes a call, any other penalty as per that is the conclusion, Milord.
That is the only way out.
That
So
is the only
that
way
to be
out.
sent back.
Or in extreme cases, your lordships also interfere. The person retired or something had happened that
He's working out there.
yes,
So,
Milord.
yes.
In those matters, lordship also take a call. It's not that each and every matter your lordship has to send to the disciplinary authority, taking into consideration.
Dismissed.
Yeah, my lordship.
You are dismissed.
Yes, dismissed, but my lordship, that with regard to, my lordship has passed one order with regard to calling of the enquiry report with this particular petitioner. One another departmental proceeding was with where
Milord,
enquiry
in a
report was not
subsequent
sub-
proceeding, he got dismissed. Then,
Yes.
Milord, he approached this honorable court by some other one.
um,
And enquiry report was not furnished. Your lordship was pleased to set aside the order and remand it to the disciplinary authority
As of
directing.
now, he's working.
As of now, he is working.
okay. But,
Yeah,
only
inquiry report was not given, so I, under 311.
yes, my
Yes.
lordship.
Your lordship was pleased to set aside inquest.
The
In fact, I also placed the records before your lordships in that matter that nothing was done.
that is on the.
Enquiry report was never communicated to him. Lord, I placed the records before your lordships.
Therefore, as of now, he's in service.
Yes, my lord.
My lordship, I have to ask, but I think he's on the verge of retirement, February or March or something like that. I don't know.
What is the present?
I'm not exactly sure. My lordship may kindly see. Yes.
But even then, my lord, if he has not retired, my lord, short time can be given. My lord, at the time of filing of the writ petition, he
No,
was 49 years.
Now it is, he'll be 58.
50,
What is the retirement age?
60.
59.
Lordship can pass an order saying within giving a specific time. That will be, my lord, proper. Within 1 month or so, my lord.
He is anyways going to get out
In
there.
the other case, my lord, the allegations are not very good.
That is a different aspect
Which
of the
is,
matter.
my lord, I'm not trying to influence your lordships, my lord. I'm not trying to, it is not at all my intention, but allegations are something serious. Sorry, my lord.
Corruption?
Yes, something like that. my lord.
No, like, I was not. But that is a different aspect. My lordship, here my.
Charges were proved and only my lord, fault remain in the DP was that the inquiry report was not furnished. So that's why lordships very rightly, my lord.
In that one other aspect was also there. In that order, this order has been referred, my lordship. So my lordship was initially granting one stay. My lordship might remember in this case. Thereafter, when my lordship had remanded the matter for the inquiry report, the stay, my lordship, we didn't continue because it had no retrospective effect. Because after that report, it was pending before the LR branch, my lordship. So in that, this has been reflected. So my lordship.
I state that alert.
Yes, my lordship, but
And-
since it was remanded back to
State
the
the
station
decision
of
of the
inquiry, no, will not influence, my lordship has passed on
Ah.
order, will not influence this, yes.
Now, what has happened to the
My
alert?
lordship, since it went back to the inquiry stage and that, so that has become
That the
infraction.
interim order has no.
Yes, my
no
lordship, no,
relevance,
my
no.
lordship.
So it is one penalty. which
One
is made.
penalty. That is my humble submission, my lord.
So it is one penalty. So therefore, we hold it. And therefore, it further mentions that after this period, then he will get full interest.
Correct. That is the proposition. That is the law.
With regard to the Nazir, my lordship, the first part was, it was not proportionate also with regard to the civil Nazir, my lordship, it was, I think, my brother, a reduction to only lower time scale of pay with regard to the Nazir.
The reduction of basic pay from 19,750 to 14,820.
Yes, and not the other part.
For, no,
Right.
other parts also there, my
No,
lord. I have, my
no,
lord, I have
order.
noted down this. If required, my lord,
Mm.
I'll place the order before your lordship.
My lordship.
We place the order. We
Yes.
have it on next Tuesday. Sure. We'll dictate in the court this type of.
Fine, my lord, fine.
Because with, my lordship, with further direction, that part is not there with regard to the Nazir, my lordship. Nazir order to that.
No, that your lordship will consider after
Yes.
seeing the order, my lord.
No,
I don't-
if that is so, then it is a minor penalty.
My lordship.
Yes.
If
No,
that-
no, no.
No,
It
if
depends.
he is reducing-
Reduction of
reduce-
basic pay is itself is a major penalty, my lord.
No.
Here, reduction.
Even, it's also a major penalty.
Now, what is here?
Reduction of pay. Here also reduction of pay.
But with cumulative effect.
Yes, cumulative effect.
And there, Nazir, not cumulative.
No, in my, so far as my, my lord, I just see from the records, my lord, if Raji's order is there, my lord, I'll readily give, my lord.
My lordship.
Exactly
some while
same
back
order
my
has been passed.
Some while back, my senior has read the Nazir order. That was, that's why I was saying. Nazir
Nazir?
order to পঢ়িছিলে নহয় আপুনি? Nazir cost.
Evidence to
Yeah,
position.
no.
My lord, I'll just place the Naji's order, my lord.
So this DP is for two persons.
Two persons, my
Yes.
lord, combined DP.
Combined DP.
So here the DP does not have the order.
Yes, it has.
If it is the DP,
Penalty order, my lord,
will have the order.
Yes.
Order sheet, charge, allegations,
evidence.
inquiry.
There is another
report,
file, my
and
lord.
arguments. There is another file.
Yes. It contains the maximum of the documents are, my lord, I'll just 1 second. my lord.
No, I think I know. For Nazir, the inquiry officer's report is only mere negligence.
Yes.
Allegations were different, my lord.
Maybe
so far as
what I
Najir.
said, in view of the above, it is found that the charge of negligence on the part of NK Taran is proved and rest allegations are not proved. Whereas as regards the petitioner, impropriety, misconduct, and gross negligence in duty
Well, allegations were different so far as Nazir is concerned and so far as the petitioner is concerned. Nazir allegation were that the advocate and the petitioner produced the inform you not to evict.
Is the matter on 4th of August 2026, 3 p.m.
God bless.
Mr. So-and-so shall produce the order of penalty of NK Tarang, which was imposed in pursuance to the DP case number 1 oblique. 1 oblique
1/2011.
2011. The records which have been produced is returned back to be produced again on the next date.
God bless, my lordship.
Seal to Toran or penalty order. Deeply obliged.
Yes, what has happened?
Lordship, may it please your lordship, another group of villages, they have filed a new petition, lordship, with regard to the same land, lordship, with full pleadings and
Who?
from the same village, lordship, and then the adjacent village also. Actually, now there are 5 villages. From there, the petitioners are there, and then they have been affected by this Mahabal cement plant land allotment also, and there is a connected mine also, lordship, mining lease, which has been which was auctioned to the Mahabal's parent company, my lord, the JK Lakshmi Cement. So
That is another aspect.
that is another aspect.
Auctioning would come within the ambit of the mines and minerals regulations.
Yes, lordship.
As well as the rules framed therein
Yes,
under.
yes.
It is another
That
aspect.
option, yes, lordship. But with regard to the land, lordship, because there also there's been no land acquisition or no determination of a rights, lordship.
Those petitions are not here.
Not here, lordship. That other petition is going to be listed on 17th, lordship.
That petition they challenged it.
Yes,
Heard from your lordship last time whether they challenged the lease deed. So in that petition, we just received notice, the company has. So it's a different set of petitioners.
That is
And they've challenged the lease deed, they've challenged the mining option,
allotment orders.
whole bunch of things.
Yes, lordship.
Whether law, it's a different set of.
But this
petitioners.
is different from that, na?
Yes, Lordship. This is a different.
The-
Here, your case is simple.
Yes,
The look
lordship.
here, we are the owners of this land,
Yes, lordship.
and these lands have been allotted to them. Or for that, forget about Mahabal, we are not concerned, even if we don't consider, the state has appropriated the land
Yes, lordship.
without making payment of compensation. That's it,
Yes, lordship.
isn't it?
Yes, lordship.
Their stand which was taken by filing an affidavit and more particularly bringing the geotech thing
It was not geotech.
is
lordship.
on the basis of that, look here, their village is far away from the area which has been allocated to the petitioner in WBC number 337/2025. Then I put the question to them by way of an order, and as to how there can be a geotech location, taking into account that there is no map prepared. There has to be an original map.
Yes,
Sketch
lordship.
has to be there
Yes, lordship.
to make a scientific or having a geotech location or anything, that whether your village is how it is to be there. It has
boundary
to be
lordship.
on the basis of some markings,
Yes,
how it is there. It may be, there is one document which is there with you and they say they don't have the document for the other village.
Yes, lordship. Yes, one village was verified, lordship.
Village which is 5 kilometers, there is a document. The village which is closer is taking the problem, 500 meters. But they have
So
filed an
are you in
affidavit.
occupation of the land? No.
We are in occupation of the land, lordship. We are still farming on it, though they have demarcated it. But since we don't have any other, we don't have.
Then
Yes,
the
lordship.
land has been allotted to us or not. We have done 90% of demarcation. The 90% demarcation, we have not displaced it. But the 10% is what we have not yet, the council has not yet demarcated. I don't know what the status there is. We are just
And in the meantime, you have made the fencing.
for 90%. And for the 90%, nobody has been displeased, is my instruction. And you said so.
Lordship,
Just one more thing, something that Mahabal has to apprise your lordship. I'm item 6 petitioner. Mahabal is the company to whom the land was 3,000 bikha was allotted. There has been a change, development. What had happened is the mining lease, the letter of intent has gone to my parent company, JK Lakshmi Cement. So to bring in harmony, now the lease also has been transferred to JK Lakshmi Cement. So which is why in the course of, I'm also awaiting complete instructions. In the course of the next few days, we'll file an application to amend the course title and the registration, because Mahapal now no longer is the person who holds who's been granted the lease. It's my parent company.
So the lease has changed.
The lease transfer in line with whoever has got the LOI. There have been
So that means as of now, you don't have your locus.
Does not, yes, your lordship. Petitioners do not have, have not been granted. That has been changed. I do not know
So
the
you
date,
don't have a case today.
which is why I'm saying that lordship.
You have to file a separate petition. It's a different company. Parent, mother, father company would have no business. No, not possible. It is a different case, cause of action. This is a different cause of action. Your right springs only now. You have got a lease now. You want to protect that lease by way of filing a writ petition. It is well and fine. You can do so. But if you don't hold the lease, there is no allotment in your favor as of now. Nothing remains.
Transfer or a proposal of, I'm also awaiting the confirmation. I think there has been a transfer.
What have you done?
Lordship, regarding this, today morning only I came to know from my learned senior lordship. I am also not aware about the fact, lordship, because in 467-2025, in that case, we have filed, as per your lordship order, we have filed the additional affidavit where we have said that.
How did you find out?
Lordship,
How did you find out that a nearer
Yes,
village
yes, yes,
is not encroaching upon your allotment?
yes, lordship.
How?
Lordship, that we have already stated in page 116, lordship.
How?
That sketch map was prepared on the basis of GPS coordinate and recorded.
Understood. My question is GPS coordinates, how do they come in?
As
How
per,
do the GPS coordinates come in?
as per, my learned friend was supposed to file reply to this.
What about them? You will ask me. My question is, how did you find out the GPS coordinates? Problem lies there. You see, you
Okay.
have to understand. Have you read my forest judgment?
Yes, lordship.
You read it. Did you see how the scientifically the forest boundaries have been delineated? How do you do it? First, you have an original map. Then you take a drone, put a picture from there, and then put the picture and superimpose on this original map. And then you can find out that how it is. And thereupon, you have to use the rover facilities to find out exactly which are the boundaries of this land.
Yeah.
You have not done that. Merely by saying that you have GPS coordinate. That is why I asked you, how can you have a GPS coordinate? That this coordinated land there is this or this.
Because drone survey was done as per my information.
How is it possible without the original boundary? There has to be a boundary, no? It has to be superimposed on that original boundary map. Not possible.
In this matter, lordship, we are being leading by Advocate General, lordship. So he will apprise your lordship about the same, lordship. I will definitely inform him about this one, lordship, the query which your lordship had raised, lordship.
Now you are not disturbed.
Lordship, actually, we were disturbed.
Protection.
No. You.
Lordship, right now, we don't exactly have the land, Lordship, but we are still farming on the land because it is only bamboo boundary, Lordship. And we don't have any other land to farm also.
No, my question is, you don't have the land.
Yes, Lordship.
How? Why? On the other hand, you are saying that you are farming. How is it possible? Both things?
Lordship, they have demarcated with bamboo, Lordship. So the villagers, they're just crossing over and they're planting, they're doing their farming there, Lordship, because they have no other option, Lordship.
Instructions are.
No, first, you don't have Lucas today.
Yes,
Yeah.
Lordship. They're entering the land to do their farming, Lordship.
So that means you have been displaced.
We have been displaced.
Okay.
Yes.
Now, what is your document of title?
Lordship, our title, we don't have title documents, Lordship, because we are paying only hoe tax, Lordship. That is in lieu of land revenue, Lordship.
Okay. Now, how do you demarcate your land?
Lordship, according to the code, Lordship, there is an act of the North Kachar Hills District Constitution of Village Reserve, Act 1976. Then section 7, it defines what is a village, Lordship. It says a village means a revenue village having a distinct village boundary recorded in the boundary register maintained by the Land and Revenue Department of the District Council. So they
So
are
for
supposed
one
to.
village there is.
Yes, Lordship.
What about the other?
We don't have it, Lordship.
You
The
don't.
council is supposed to have it.
Council doesn't have it. Then how to do it?
Lordship, Lordship had indicated that it should be according to the through a proper GPS survey, Lordship.
Anyways, one thing. If these people are in possession, they may not have a right over the land. But don't you think that they should be given some compensation on account of their use of the land being they come within the ambit of person interested? Why you're not giving some compensation?
Lordship, there was a notification which
Lordship,
was filed earlier.
Entire Dimanasaur district is a non-cadastral land, Lordship.
Understood, but these people are there in possession. If they are in possession,
Yes.
don't you think that there should have been an exercise being carried out to that effect? That these people are there in possession? Merely remaining in possession also gives some right?
Yes,
In
Lordship.
on many, we could see in many land acquisition matters, the land has been, even in government land, Zirat is paid.
Yes, Lordship. Lordship,
See, the thing is, if these people are being affected, whoever it is affected, I think the government is allocating it to a big company. Now, Madam's Mahabal small company goes and now becomes a bigger company of J.K. Lakshmi. So J.K. Lakshmi comes in. It's good. There will be more, all these things will be there. A lot of, it's a big company. It's good for a state. But my question is out here is when you are giving it to a group big company, they are investing. Obviously, they have a lot of money. Earlier, Mahabal did not have money, but J.K. Lakshmi has a lot of money. Why are not taking some money from them and paying them?
Lordship,
Lordship, yeah, sorry. Begs the question. They have not been able to establish possession. That is, the prayer is that.
Lordship,
The prayer is clarify whether a land is allotted.
petitioner has
We do one thing. We pass a status quo order not to touch anything on these lands. Then obviously they can prove it. You want that?
Lordship,
Huh?
earlier,
No, you tell
Lord-
us. You
Lordship-
want that? We can very well pass an order of status quo to the effect not to disturb anybody's possession, which should not be in interest. You see, at the end of the day, they are tribal peoples. So when they are there, they are the persons who are original. You cannot say that they are outsiders.
No.
Whatever may be, they are there somewhere. They are carrying out their cultivation. You have to pay something. The state has enough resources and get the resource. And who you are going to pay to him?
Lordship,
This J.K. Lakshmi now.
the petitioners had earlier filed a case where the land, their land were being means taken by the council. That decision has been cancelled. Now the council has allotted the land to the cement company from the 6,000 bighas of land which was earlier allotted to the industrial state, Lordship. That we have already stated.
Understood.
From
But
their
these
3,000 bighas.
these 6,000 bighas, I know it.
Yes, Lordship.
Are government lands. Let us assume that these are all NC Hills Autonomous Council's land. There's no quarrel. Let us assume that this is a part of that 6,000 bighas. Taking into account that they are in occupation, why you are not making some payment as regards the possession and then clear it up? Why I am saying so makes no sense. They are having a big industrial company, 6,000, how much? 3,000.
3,000 bighas.
So 3,000 bighas have been given to it out of the 6,000.
6,000.
So you have a particularly allocated area. Now, tell me, you say that it is a 6,000 bigger land which was with you.
Yes, Lordship.
So it must have been demarcated.
It must have been. It must have been.
How are you saying that it is a part of 6,000?
Because we have already filed in our affidavit, Lordship. We have.
Understood. So have you demarcated the 6,000? If it is 6,000, it must be including in many villages. As per section 7, which are the villages it encompasses?
That I have to ask, Lordship, because I am also not aware whether that land was demarcated or not, Lordship.
So therefore, if you are saying this out of 6,000, this 3,000 has been given, you give it. There's no quarrel. You have been in all over the state of Assam, lands are being given out there by or taking lands by this Assam Mala scheme, whatever the PWD wants, they are taking over the lands. My question therefore is, first of all, if they are there, they are person interested, they have been cultivating out there, why you are not? Are there any cultivation?
Yes.
What cultivation are there?
Rice, Lordship, rice, mostly
See?
Gauhati.
Rice cultivation is there.
Sesame seeds.
And you can
rice.
find out, I think that scientific technology you have or no? NC Hills, you have. Very well.
Because, Lordship, in page 62, that annexer 11, Lordship, I am just pointing out to your Lordship, that we have already allotted the land in the year 1998 to this additional director, industry and commerce.
Very good. So you have the boundaries of that land, na?
It must have.
No, what land you have allotted? Is there any boundaries? Are there not? How do you identify these 6,000?
This is all along Lanka Garampani Road in between 26 kilo to 29 kilo. That is some kilo something.
What?
Don't know.
This is the land. No demarcation.
Because here demarcation is not stated, Lordship. At that time.
What is that kilo? From 26 kilometer to 23.
29 kilo. No,
No, it's kilometer, no? It is the mileage. You see, that is the milestones.
Yes.
So from this milestone to that
That
milestone,
is being
this is
allocated
the
to-
entire area you
Yes,
have
yes.
given.
Allotted to the additional director, the then additional director, industry and commerce, Lordship. From that 6,000 bigas, now 3,000 bigas were being allotted to that.
So are you giving them on a lease?
Yes, Lordship.
Do you have boundaries there? Or that is also not there? Huh, madam, that is also not there. Page?
187.
Your with petition? No, the other one.
I can cite.
467, Lordship.
Page 187.
187 is P. That is giving us the current piece, and the next page is the annexure 12. Lordship has about the page, right?
187 is to the director Mahabal Insurance with reference to the above, measuring 2,000 bigas situated all along Gorompani Road in between 26 to 29 Umrangsu, which are earlier allotted for the industrial estate so-and-so, is hereby allotted to you for setting up the cement at the moment. So here 2,000 has been given.
Yes. And
Then-
then, and Lordship will see the next page, which is the lease.
Now, where's the lease deed?
That's what, next page, 188.
So this is Patan. Here you have a Patta.
Yes, that is what, schedule. And boundary is.
Patta 340. Unsurvey, village unsurvey Umrangsu. Organa Haflong. District Dimahasau. Area content 2,000. North Council Khasland, Council Khasland, Council Khasland. So there is no other land.
Lordship will see the period in the lease deed, Lordship. It starts in 2010, Lordship. That is the first clause.
No, that is 2010. In every list that we used to write 2010. That is not in every, that 2010 is being, I don't know how it will start from the day.
Last till 2040.
Commencing from 2010 to 2040.
So 40 is when it gets done, and we have that much time. So we got it in 2024, so we have to 24 to.
And This particular company did not come into existence in 2010. Obviously, it is apparent. It is not. You did not come into existence. Lease it on the face of it is bad.
This is the format that council.
How can it be?
Lordship,
If
that
you are
is
giving it for 30 years, it has to be from some particular year.
No, this is the format which,
Yes.
if today also, if they were being granted the lease, that the lease will start from 2010 only. It's written.
The date is 15/10/24, your lordship, for whatever it's worth.
No. See, the term of the lease is
And it's
30
not
years
fair, yes, that
from
was the question.
2010
Yes,
to
yes.
2014.
Yeah, we were told that is, the company was told that is the format. in
No,
which
it
they
can't
gave.
be. And it was signed in 2024.
Yes.
How is
Next
it possible? No, Mr. RM does, I think high time, they cannot be so primitive enough. The NC Hills cannot be primitive enough to put lease deeds like this. The lease deeds have to be proper. You say that this is under what provision of law you are doing it? That you will be dating it from 2010? Tell me, give me a good reason. How is it possible? A company comes into existence in 2020 or whatever may be, you agreement signed in the year 2024, and you say that it is in 2010. Don't you think that the entire basis or the edifice of the lease deed gets shaken because of your what you are thinking? And what is the basis from that 2010? I don't think the NC Hills have any law to that effect that it will be given from 2010. No. It is, I think, the brainchild of this particular officer. Which one? The revenue officer. He doesn't know how to count. That from 2024, if we have 30 years, it will be 2054. So it is very difficult to count. So let us count from 2010. 30 years is 2040. It appears so. There cannot be any other justification. And in the 21st century, even the kings who were the kings would not have done this mistake on the basis of which now you are following it. You don't get an immunity, or you cannot act in such impunity to do all these things. It cannot be. Did it ever heard of 2010? It should have been 2024 to 2054. Then, or is it difficult to count for this officer? Something must be there.
Because
Then provide your good advice and your calculation.
regarding this,
That in Gauhati, the standing council can very well calculate from 2024 to 2054, 30 years. Here, Mr. Das, whenever a company, you want that company to come for industrialization, does it show properly for a company of a magnitude of JK Lakshmi or Aya? Therefore, you have this smaller company coming, Mahabal Cement. A company of JK Lakshmi or Lafarge and all these things, where you are rich in limestone. That is the reason why they are doing it. You are rich in limestone. And therefore, you are having this mining and all these. So, if you are doing it to that effect, does it look nice? Because this is a company, how are you going to show it in the balance sheets? That look here, they only understand from 2010. Isn't it, madam?
That was the question.
Huh?
Even the company instructed.
You also must be feeling ashamed being from Assam that this is the state of affairs which is happening. I think the new lease is properly done. I hope so. Don't do this. And whatever it is there, find it out. If they are person interested, pay something. And Madam, you also should advise your client, do something to talk it out and finish it up so that we can close this type of litigation. Because this is not in the aid. People would not invest in Assam if these type of litigations carry on.
Absolutely.
Yes. So therefore, if a bigger company or anybody has to come, there cannot be a thing that in the one. Obviously, there has to be a sustainable development. There's no quarrel. When they develop out there, they have to also do it within the strict purviews of this particular Yeah, and maintain the proper AQI. Because of that, they come hail from Rajasthan. You are from Rajasthan? JK Lakshmi is from Rajasthan. No. They are Calcutta is Mahabal. JK Lakshmi is from Rajasthan and all.
You're right, yeah.
Yeah, so it merely because they are in Rajasthan where the AQI is higher doesn't mean that in NC Hills they will have something to that effect. Isn't it? Take care of those instead of having this 2010 to 2040. And I'm not going to enclose the other one. Other petition is different. That is not to do. If it comes before me, it's a different aspect of the matter. I'm not going to take those matters. But the only thing out here is you bring in the, if your new lease deed has come in, but if you are doing a new lease deed, do it properly. Don't go on the basis that we can't calculate from more than 30 years from anything else.
Agree more. But Lordship, it's in there.
Huh?
We have to decide. It has to come from the council.
No, because again, the problem which will happen is this. The mining lease which is being granted has to be given in terms with the Mines and Minerals Development Act. Read with the rules which provide the limestone mines, how it is to be given, Rule 7. Because these are other than atomic energy. Now there, you have the mining plan. Mining plan has to be approved and all these things have to be approved. Now if you put a date of 2010 and finish it off, then how can they get a proper mining lease? You'll have a problem in getting a mining plan. Think better. Or was this only a test to see how much opposition we get?
Lordship, there are more issues that there, Lordship.
Anyways, chalo. So what orders are required to be passed? Your affidavit is, you find out as to whether your village is which village?
This is the Nobody
So
Longkopro
long
village.
tree.
Mm,
Now they put, and what is the, what is your NC Hills Haplong? Now we see a particular dark number here. A patta number 340. Now, how are you having this patta number? Because another thing, Mr. You see, unlike the rest parts of Assam, 6 scheduled areas, the ownership of the land is the people. Isn't it?
Lordship.
I
Yes,
think the
Lordship.
same
Tribal
laws
land.
like Nagaland, Meghalaya, and all these things
Yes,
will
Lordship.
apply.
Yes, Lordship.
The state doesn't have the ownership of the land.
Council.
So you have a land. Let us not further intricate or go deep into this, which may land into more troubles. So better off do something properly. Okay, when do we have it? And when you are withdrawing this petition? We withdraw this petition and file another one if it is necessary. But you can't amend this because you come into existence now, isn't it? This matter again on. You want it?
As per your law.
Well,
Any date, Lordship.
any day. Hello. Let this matter be listed on 17th of August 2026. In the meantime, you are supposed to file a reply.
No, Lordship. No,
You're not going to.
no, I will not file.
In the meantime,
No, no.
the respondents in the North Kachar Hills, no?
Yes, Lordship.
North Kachar Hills.
Not such a.
The revenue officer of the North Kachar Hills shall file an affidavit as to whether there is any occupation or use of the land by any other person, land which was allotted to the respondent number 7, by any other person by carrying out any cultivation. The said be brought on record by filing an affidavit on or before 14th of August 2026. Let's see what happens. If there are somebody, consider giving that, because this will be help you out. Definitely.
May I please, your lordship? Matter related to non-issuance of land sale permission, lordship.
Huh?
Non-issuance of land sale permission, lordship, by the respondent authority. Earlier occasion, lordship, it is not opposed before this honorable court, but they have submitted rejection order, annexure I, page 52, and annexure J, page 53. lordship.
Why the matter was fixed on 37? Somebody mentioned it.
So, lordship,
Anyways, notice they have not filed the affidavit
yes, lordship.
whereby land permission has been rejected. Why have you rejected?
Lordship, as per the order, your lordship, the said at page 53, lordship,
Page
53,
3.
lordship, at the last paragraph, the said land, then
Page
53, lordship,
yes.
at the last paragraph, the said land so and so is under Kalaigaon tribal belt, notified in the year 1948. Lordship, the land falls under the tribal belt, your lordship. So in that, and this order was placed in the previous proceedings, and on that count, it was closed, your lordship.
Yes.
Lordship, after that, I have filed an RTI, lordship, and thereafter, lordship, page 68, lordship,
60?
68, NRC of 1952. And
Yes.
page 70,
There?
page 70, 1971,
70.
1971, and first one is 1952. That's it.
There? What is this?
Lordship, the petitioners ancestor stay in that area, lordship, tribal belt area, before independence.
68 is what?
For 52, lordship. 68.
Page?
Page 68. Page 68.
What does it say?
Is a
Whose name is this? Name is
Sujo.
Sujoy. What is the name?
Sujo. It's an elder brother.
Who is he?
Elder brother. See?
Huh? Elder brother.
Not elder brother. My father.
Father's elder brother was staying out there. He was 30 years.
Father's elder. Yes.
When? This is recently done.
So I have collected from the RTI, lordship.
This is vote year 1971. How can this court look into all these things? You have to show something else. Your voters list. Show your voters list, all these things.
Voters list, lordship.
1948, because it was prior to independence.
I know they have no.
This must have been prior to just your the independence. This happened immediately after the independence.
Yes, lordship.
So were you there prior to the independence or not? The family,
Yes, lordship.
you were there.
Yes, lordship.
Where? These are not documents to that effect. Some court have issued notice. But that doesn't mean something. You want to sell it. Who wants to sell it?
It is number one, want to sell it to me.
Huh?
It is number one, want to sell it.
To you.
Yes, lordship. Petition number one to petition number two.
Ask the petitioner number one to sell it to some other person who belongs to the tribal.
Lordship.
Only way out.
Sometime maybe given, I will collect the document. Lordship.
Huh?
Sometime maybe given, I will collect the document.
Mr. Gigi Gogoi, appearing on behalf of the petitioner, seeks for some more time to place additional materials to which should show that the petitioner's predecessor, the petitioner number two's predecessor, were residents of the area. Residents of
Lordship, one more, Lordship. Page 36, Lordship.
of the Kolaigaon tribal belt prior to 1948.
Lordship, in that area, I am only stay. Permanent residence there, Lordship. Page 36. One Jamabandi
Is
also.
the matter, you have documents?
Yes, Lordship.
Where? That is what I have been asking you, where?
Page 36.
6.
Page 36.
What is that?
Joripua গাঁৱৰ ম্যাদী জন্মবন্দী, Lordship.
Huh?
Gauhati bill, Moja Urang. Under BTC.
Who are these?
This is my name.
Bholaram Soikia?
Yes.
The father.
Yes, Lordship.
This is in? So you want to come under 165?
Yes.
160? That you were residents of the same locality?
Yes.
Chalo. But to come within that, you have to come within the ambit of 163C. Okay. The persons belonging to other classes of people residing in the belt or block from before the constitution of the belt or block. How do you show that you are the owner of this land prior to 48?
I will-
Notice. That is the order which I just was about to pass, but you again interrupted.
Okay, Lordship, I will submit.
That is what I passed. How much time?
2 weeks. 2 weeks time maybe.
Is the matter on 28th of August 2006. Submits that he would find trace out documents which would show that the petitioner number 2 or his family members have been resident of the Kolaigaon
Tribal belt, Your Lordship.
tribal belt prior to 1948.
Must.
And submits that an affidavit in that regard would be filed. So list this matter again on 28th of August 2000.
Lordship, respondent number 3 and 4 has filed affidavit, Lordship. Yesterday I have received, Lordship. I have to file a reply, Lordship.
You want to file reply?
Lordship.
Counsel appearing on behalf of the petitioner submits that the petitioner would like to file a reply. If it in opposition, filed by the respondent number.
3 and 4, Lordship.
Oh. Is this matter again on 17th of September 2026. In the meantime, The reply be filed on behalf.
Lordship, one more aspect, Lordship, Lordship, order dated 18/5/2025. There was a direction to the senior Lordship, High Court, Lordship.
You have filed your affidavit,
Well, we have filed the affidavit.
file your reply.
Lordship.
Obliged.
May it pleases your lordship.
Affidavit not filed. For that matter, yes, what happened?
Yes.
Has the records been transmitted?
Record transmitted, Lordship.
The district judge,
District Judge sent a record to the LR, Lordship.
when?
Lordship, that, Lordship, once 7/2024. Once is 1/7/2024. But no, 30/06/2026 is the sending date, Lordship, but the receiving date, Lordship, it is
On
second
receipt of this. on
2nd July
receipt
2020.
thereof, this court by letter transmitted the appeal memo along with original to the register Gauhati High Court requesting for continued comments of the Honorable High. Further in view of the pendency of the present requisition. Is the register provided?
One letter we have received. One communication we have received from Secretary of the Government of Assam Judicial Department to the Registrar General asking for opinion in this matter. No, there is no point in for us to give opinion because it comes under Rule 13 of Ministerial Service Rule, wherein the Secretary Judicial Department is the competent authority to.
They are referring to some judgment.
Yes, Lordship.
Of 1/4/1992 passed by the High Court in the case of Gauhati High Court by the State of Assam reported in AIN 1993 GAU 11.
One judgment.
What did you say?
Yes. That judicially materialized. But they-
What to do?
We have to wait for the.
The judgment is a difficult judgment. Means, you see, they, although they refer to the Assam Judicial Service 1967 rule, but by dint of 235 and that judgment of the Supreme Court, whereby the ministerial staff come within the ambit of the of the jurisdiction of the Gauhati High Court, same principle will apply. Power is there.
No, this judgment is with regard to the ministerial staff. But here we have got the rule, ministerial service rule, rule 13. 235 is open for all, but in rule 13, it has been specifically provided, you know. Every member of the service shall have the right to appeal from the orders of the district and session judge to the government, that is secretary to the government of Assam Judicial Department. And this is a 309 rule, specifically concerning the ministerial service.
Is the Assam Judicial Service Rules 1967 not also 309 rules?
Look, I'm sorry, look, I haven't seen the,
This is also 309 rules.
even
Then also it says that you have to take the AR because otherwise 235.
in that context, it has been.
Independence of the judiciary.
Then you have to follow.
So this needs to be again looked into properly, the judgment.
I also have a look.
And again, an interesting judgment on that point. Now,
Yes.
if that be so, now they are, I think, you have to decide on the basis of recommendations. That is very difficult. If you have to decide on the recommendation, then the authority will be different. You have to take the year, but the decision can be, I think the decisions of imposition of the penalty will be the High Court. That appears to be better. This is a very touch and go point, very difficult point now.
But we will take up some other thing, I'll just check up and I'll
You
just.
have a look at this because this has a far-reaching consequences again.
Yes,
And you have so many judgments delivered by me again.
yes.
This is again another on the question of punishment.
Mm.
And this judgment, if we pass a judgment on that, here it is not the ministerial rules. But this ministerial service comes under 235, 236.
There is no doubt about that proposition that all the employees are within this obvious institution. But the thing is, why I am putting question to myself is because of existence of a rule 13.
Here also there is rule, the governor. Some judicial service, the appeal lies to the governor.
Some
Therefore, when the appeal lies to the governor will remain.
So far as judicial service is concerned, Milord, we don't have to go to 235, I think. 234 is already there.
234 is district judge.
Yes,
Others 235.
others 235.
So therefore, how do you take us action against the judicial, against the munsif who have done that in that other case? You will come under 235. And there the rules are there. The rules are being made, some judicial service rules is made not actually, though they may say, no, you see, Assam Judicial Service, one person may say it to be a rule under 309. But in my opinion, it is not a 309 rules. It is a 235 rules.
Yes, perhaps there is a provision of getting a recommendation from.
These are also not 309 rules. It will be under, the moment you bring the judicial, the officers as well as the staff, the ministerial within the ambit of 235, then it has to be, it cannot be a 309 rules. What do you say, Mr. Chaudhary? The very,
I was kind of the Hearing with great intent, my lord. Yes, your worship is perhaps right, my lord. That is a little gray area, but then, my lord.
No, because the 30235 categorically says the governor will make rules with consultation with the concurrence of the High Court.
Therefore, it cannot be 309.
It cannot be a 309, although they may have mentioned it as 309. But the power is actually when there is a consultation with the High Court in making the rules, it has to be a rule under 235. And if it is a rule under 235, the ministerial rules also has to be brought because that is why, Mr. Das,
Yes, my lord.
that is why you see that the ministerial rules which we are drafting,
Yes.
it's not the government who is making it.
No.
Government has put it, but why they are asking the concurrence from us? It cannot be a 309, it has to be a 235. And if it is a 235, then obviously recommendation is required.
But in the
Otherwise, the
ministerial
independence
service
of the
rule,
judiciary will be affected.
yes.
It's a very complicated. I mean, keeping the independence becomes very difficult sometimes, but can't help it. Like that matter, what that transfer matter, where I say the labor the labor department has no business to do this. It is absolutely the High Court who has to do it. So this is also there. You must have seen the other judgment of Register Labor Court, the other one, where I have directed making more payment and all this thing. So there also, it's a
But in judicial service rule, everywhere there is a provision, governor in consultation.
Ah.
In consultation,
no,
everywhere.
there is a further a constitution bench judgment which says the consultation has to be twofold. One is a consultation with the High Court and the other with the Public Service Commission.
Yes.
But it is said that the consultation with the High Court has a priority and has to be given prominence. And it is not a mere consultation, it has to be a concurrence. This is the word used.
Concurrence.
It's a concurrence. So therefore, the power without the concurrence of the High Court, you cannot.
But this rule of 87, subject to correction, my lord, there is no whisper anywhere like the judicial service.
Again, you have to say, like the Assam Judicial Service is also 309 retail.
Hmm.
But actually, it is not 309. It is
Right.
235. These ministerial rules are also 235. Because otherwise, the moment you bring 309, High Court loses the jurisdiction over them. You can't appoint them.
Penalty.
Everything. These people can't do anything. Be careful when you're.
I'll just check up, my lord. Yes. I'll just check up, my lord.
Madam, you may have to wait for some time because this needs a thing because they are taking steps.
Yes.
But they also taking into account the judgment placed before this court in the case of the Gauhati High Court versus the state of Assam and others reported in AIR and 1992 1 GLR 450, this court would further hear the councils, the standing council of the Gauhati High Court as well as the state of Assam on the issue in hand. List this matter again on, let's have it on 13th. 13th, huh?
13 years.
13th at 2 p.m.
Fine.
In the meantime, get ready.
Yes, yes.
Deeply obliged.
Very important. But I think we have to do it. We have to give the recommendation by them. So in the meantime,
It can be done.
it shall not be bar on the part of the Registrar General, no?
Registrar General.
Registrar General of the Guwahati High Court to provide his inputs on the on the appeal memo appeal on the material on the memo on the memo of appeal as well as other documents which have been forwarded by the Secretary Judicial Department of the Government.
Deeply obliged.
Mission? Undu. Yes, Ranima Begum. Yes, when do you have one date, Mr. Somwa?
My lord, if possible, my lord, it will come in a Thursday only. This 12th and 13th both, my lord. High Court matters, so.
Huh?
After
12 and 13,
after
when?
15th of August, my lord.
20th.
20. 20.
12 and 13 connected, na?
Not connected, not different.
What is 12 for?
12 is for appointment, my lord. Both are for appointment.
But sometimes we would also like to see how it looks.
How it looks fine, but it is not operating.
From today, it's
Oh, it's
paperless.
e-office.
No, not e-office, it's paperless. This
It's
is
paperless,
office.
but at last I have chosen to take the paper.
It will take some time, but it's very useful.
No, it is otherwise good, but I've been not able to log in.
Oh, it's
Now, if I do, because other, it was how they, we just let.
Also, should have someone for this.
one training at least.
Someone.
No, I am the person when I test and try. So only today being less matters, so I have therefore taken it up. I had 13, 14 matters, so these matters, except this item. Now, it's a very interesting thing. You see that everything is here. You can find it out. There's no problem out there. But the only thing is one needs to get used to it. With just click on the left hand side, you have the entire thing. And in fact, I would encourage the lawyers also to, we are also trying to find out the way by which this, there are 4 stages of making it paperless. First, you have to have the, what you call the scanning. After the scanning, the QC, the quality check. Then you have to go for classification. And there is another thing which is there. I sometimes forget. Now,
OCR is the main
huh?
thing. OCR is the main thing.
The last one. Now, once this is being done, you have a preparation of called the e-nothi. E-nothi is otherwise available, which is there. With that e-nothi, you get that it's like an index. Each page, everything. So that you can very well get it in there. We are now trying to get it, once it is being filed, given to us, it can be pushed back to the lawyer who had filed, has the made the e-filing. But only problem which we are facing, which I think we will be taking up in the infrastructure bench, is what is happening. The lawyers, when they make the e-filing, Mr. Chaudhary, you are the president. No. Would be now? No. No.
I have had enough.
No, what has happened is when the lawyers make the e-filing, they put certain pages which are not legible.
Not legible, yes.
Now, what happens when the reporting is being done? They correct the page in the hard copy.
Okay.
But there is no corresponding correction in the e-file. And if it is not done, this cannot be corrected by scanning. Because that document is not there.
If I remember correctly, Delhi High Court, I think there is a dedicated e-filing place wherein after the normal filing, the file comes to that dedicated place. There, everything OCR and other things are made. Then it put up to the system. It's
Because as of now,
clerk or advocate, he has to come to that dedicated place to do the OCR, because OCR is the main thing here, the indexing. Because if we give
the indexing is the classification.
exactly. So if we give to 10 scanning persons, everyone's will be different. So one place wherein everything is accumulated, and as per our requirement, it has been done and fitted to the system below. I have heard that Delhi High Court.
They have given me 12 matters, 13 matters out here. It's good. It's not bad. It's you see the exact fakes out there, and it's very easy. Just for example, somebody refers to me the order of so and so. I just click it. It comes out here. You get everything. There's easy for this. Means I don't need to. But we still have to get accustomed to, because the moment that we see the file, what is it? So
It's a matter of 10 days.
yeah, it takes some time. So this is it. Anyways,
Old school, new school.
Madam, your matter, we need, I was supposed to dispose it of today.
Lordship.
Mr. Chaudhary, what have you thought about? There are two ways I gave you.
My lord, I'll have some submissions to make. In fact, my lord, I have prepared a written argument also, my lord. If your lordship like to peruse it, my lord, then I can hand it over to your lordship. And
Chaudhary,
possibly-
giving a written argument of a matter of this style,
But then, my lord, I'll have to make some submissions, my lord.
obviously, make the submission. I only asked you with either of it. One should have foreclosed the entire thing of this. Anyways, you want to make your argument, we'll hear you on the next date. When do you want it?
Let it be next week, my lord. Next week, I might not be here. Week next, my lord, any day.
Let's have it on 18th of August. This is the matter on 18th of August at 2 p.m. for final discussion.
Our matter is given at 20 August.
Yeah, when do you want it?
20
20.
20 August. Item 12 and 13.